1-3. At the request of the learned counsel for the petitioner, list this matter again on after
Weeks.
3 weeks. After 3 weeks. Yes.
My pleasure, Lordship. I wish to mention for unlisted one AB for correction.
What is the mistake?
PSK's name has been.
Yes.
My pleasure, Lordship. I beg to mention item number 61.
61.
Complementary legal. This is the third occasion, Your Lordship. This year,
So let the matter reach, we can pass some lengthy order.
Okay.
Yes.
Wait, please, Lordship. Item number 38. May I kindly
38.
38. May I kindly withdrawn.
Hmm.
38. 38. Oh, okay.
Learned counsel for the petitioner,
Yeah,
Mr.
Rahman.
M. Rahman has submitted that he is under instructions not to press the present bill application. Full stop. Accordingly, the petition is closed on withdrawal.
Obliged.
Any other petition pending somewhere?
No, Lordship.
Yes.
I beg to mention item number 37, Lordship.
37 years.
In this case, Lordship, CD is not available. 37.
Learned counsel, Mr.
D. Soikia.
D. Soikia is present. Learned APP submits that the case diary is awaited. List again on
my love, 14, my love.
14/9/2026.
Interim kindly.
Interim order passed earlier continues. Yes.
May it please your Lordship.
Hmm.
My Lord, I beg to mention item number 1, Lordship.
What?
1, Lordship. Lordship, what happened, Lordship? This petitioner earlier moved an anticipatory bail application, Lordship, along with some other co-accused, Lordship. And that matter is listed today, Lordship, at court number 21, Lordship.
Okay.
So kindly this matter may be sent to the court number 21, Lordship, so that
can I
hearing
send
can
it?
be taken.
There was an anticipatory bill,
Bail application, and
and in the meantime, he was
he
arrested.
was arrested, Lordship.
But
But some other co-accused anticipatory bail application pending, Lordship. And that matter, Lordship, listed.
I can only say it will be listed along with that matter. I cannot say more.
My Lord, today.
How can I send it to some senior court?
My Lord, file may be sent because I make a mention before the court number 21 Lordship, to take up along with this matter.
Mr. N.H. Borvia submits that the petitioner had earlier moved an anticipatory bill petition prior to his arrest. And the said AB number
AB number 1805.
1805 of 2026 is pending before this court and is listed in court number 21. Full stop. Accordingly, he prays that the matter may not be taken up by this bench and be rerouted to the registry to be placed along with AB number
1805/2026.
full stop. Accordingly, the matter, accordingly, the registry shall verify and place the matter before the appropriate bench along with AB number so and so. You do one thing, you type it out as soon as possible. I'll sign it here itself, we'll send the file. Why now doing some other matters, you type out this matter. Okay? Act number file quantity. We'll try to send it.
Yes.
Yes.
Lordship, I have filed an additional affidavit in item number 43, Lordship. Ask me to annex some orders, Lordship.
Please,
So that will
call for it. Yes.
Lordship, I beg to mention item 62 for withdrawal with a liberty to file a fresh one, Lordship.
You are Miss?
I'm Lordship M. Bhuya.
Miss M. Bhuya, learned counsel for the petitioner, submits that she is under instructions not to press this present anticipatory bail petition in its present form and to withdraw the same with prayers for liberty to file afresh. Full stop. Accordingly, the present anticipatory bail petition is closed with the liberty as prayed for. Yes, sir.
I beg to mention item number 31, Lordship.
31.
31, Lordship. Scan copy of case record was called for, Lordship. That was not received, Lordship. So,
31. Yes, sir. What do you say?
on the office note, Lordship.
Scan copy not received on 31 as it is stated, madam. Let it be after 2 weeks.
No, next week, Lordship. Already, as per instruction, Lordship, registry has received, Lordship. So, not next week. So, Lordship, next week, Lordship. Next Monday, Lordship.
Since the scan copy of the TCR has not been received, comma. Place this matter again on 31st of August 2026, awaiting the scan copy.
Please, Your Lordship.
Yes.
Lordship, I beg to mention item number 23.
Hmm.
Matter may adjourn for the day, Lordship. Any day after 1 week.
At the request of the learned counsel for the petitioner, comma, though the scan copy of the TCR is available, comma, list this matter on
Next Monday,
to filled up.
Next month is 7, my lord, that you are 10th, my lord.
It's a bail petition, sir.
No.
Scan copy received.
still go
Third
already
minor.
received. Lordship.
Third. 3rd of September. Yes.
Maybe the Lordship, I beg to mention for listing, madam, anticipatory bill application, madam.
Filed it.
Why, madam?
File number is there.
Yes, madam.
No objections. When do you want it?
Any day, madam, yes, Lordship, please.
We'll have it on 26th. 26.
Yes. Earlier, madam.
As per
Yes.
telephonic instruction of my plan man, always liberated.
Mr. Ali, learned counsel appearing for the petitioner has submitted that he is under instructions not to press the present bail application. Full stop. Accordingly, the present bail application is closed on withdrawal.
Telephonic instruction that per my.
Telephonic instruction. On telephonic instruction is submitted. Yes.
Actually, your Lordship, this is 483 application, my lord. Commercial quantity involves here, my lord. This case, my scan copy of the TCR may be called for.
You are Mr.
You Khan.
Heard Mr. U. Khan, learned counsel appearing for the petitioner. Mr. MP Goswami, learned APP is present. Call for the scan copy of the TCR. In connection with
Special NDPS case.
special NDPS case number 07 of 2022 pending in the court of the learned special judge Bilasi Para. List again on 7th of September 2026.
Deeply. Another application out of same affair is pending on, is fixed on 27.
You are Mr.
H. Ali.
H. Ali, learned counsel for the petitioner submits that another bail application arising out of the same FIR is pending before this court in the form of BA number
2399.
2399 of 2026. List along with the aforesaid bail application
On 27.
on 27th of August 2026, comma, since it has been stated that the said bail application is listed on that day.
Hello.
Yes.
Wait, please, Your Lordship. Lordship, this is a regular bail application. Affair at page 7 onward. Your Lordship. Allegation against the petitioner under section 20B
Ah,
with 25 NDPS Act. Your Lordship. Intermediate
commercial quantity.
Intermediate quantity.
Oh,
Then-
ground of arrest is commercial quantity? No. I'm wrong.
2 point something kilogram ganjas were recovered.
2.256,
2.5.
Page 13?
page 11. Page.
Now, page 13, why does he put the ground of arrest as commercial quantity? Page 13, ground of arrest number C?
Yeah.
Huh?
It should not be, my lord.
Huh?
It should not be.
Cannot be.
Cannot be, my lord.
Have your instruction, this man
Yes.
has been, maybe just like I read that only sentence,
Logic.
just like I have read that only sentence,
Logic.
he might be behind bars for that reason.
No, my lord,
How do you know?
because he was, today is 30 days, my lord.
Huh?
He was caught with 2.2 kg. And it is
CD when?
85.
When?
What date may be?
My lord. On 8th, my lord.
Hmm? 8 to fuck,
Your Lordship,
intermediate
today's-
quantity, sir.
Yes, ma'am.
And all materials for smoking is found with him.
Yes, my lord.
Yes? So definitely he's not selling it around, he's having a good evening.
It will be, my lord, 45 days, my lord.
No, since all smoking material is recovered from him, he enjoys a good evening. He is not making profit out of it.
He also enjoy, my lord.
Okay. 8th September. Call for the case diary. The recovery of the contraband amount is of intermediate quantity. List again on 8th, calling for the case diary. Hmm.
My lord, petitioner is behind the bar for last 34 days, my lord.
Hmm.
Although there are some small quantity of ganja is recovered from his
Small
house-
quantity.
from his house, small quantity. But police has taken up 3 incidents together, my lord, and it falls under now intermediate punishment. Lordship will find that the Azahar at page 12, my lord, relevant portion. Lordship will find at page 15, my lord. Page 16. As regards the petitioner in concern, my lord, page 16 down below, my lord. The following items were recovered during the search of the house of Segundas. My lord, 3 to 8 grams marked as P1.
Page number?
Page 16.
16.
Down below, Lordship will find that the following items were recovered during the search of the house of
Segundas, huh?
Yes. 1 black colored plastic polythene containing suspected ganja, weighing 334 grams with plastic polythene. The black color polythene weight 6 grams, net weight of the suspected ganja is 3.28 grams. 328 grams. Now, they have connected all these 3 incidents, my lord, recovered from different persons. The first person, he rattled us. There is a recovery of 5.092 kilograms of ganja, my lord. From Segundas, my lord, the petitioner 328. Lastly, my lord, the one Padma Saikia, the 90 grams, my lord. On the basis of the alleged statement of the accused, co-accused, they have taken up all these 3 matters, my lord. Individually, otherwise, it is a case of small quantity, my lord. He is behind the bar for last 34 days.
34 days. From where?
The forwarding at page
That's why
18,
kindly
my lord.
page 19, last paragraph, my lord.
Ah,
Last but second, my lord. Page 19. During
This is
that is the, this is what I had in mind. He had finished his stock.
Lordship, yes, he's finished his stock.
He finished his stock before the recovery. We'll have it on 7th, sir.
7, well, I have some difficulty, or 8 or 6.
8th.
8.
8th of
Mm.
list again on the 8th of September, allowing the learned APP to call for the case diary.
Well, okay.
8th of September. This.
May I please, Your Lordship? The matter will be passed out for the timing, Lordship. After settlement. Yes.
This is something complicated. Look into it.
Lord.
3, 4 FIRs, one after the other. POCSO and everything included. Yes, sir.
This Lordship, my lord, this regular bail application, petitioner arrested on 31/7/2026.
On the allegation of?
Allegation was as per FIR page 9.
Hmm.
And my all allegation is against the 1 and 2 as per FIR. I am the accused number 5, the petitioner Mehboob Hussain. Actually, fact, my lord, he is going to his in-laws house in 29 6/27 along with
No,
his
no.
family
Things have
member.
been found against you also.
Also, my lord, and go to in-laws house in 29/6/2027 along with my mother and family members. Thereafter, the petitioner mother came to my lord, return to Gauhati. Subsequently, on next day, petitioner wife, my lord, informed his mother-in-law that this police arrested in the petitioner, and on the condition that the other accused appear in the police, then the accused petitioner released on. My lord, this
So others are not willing to appear.
willingly appear.
Those who have done the damage are not willing to appear.
Appear. I am, my lord, I go to in-laws house.
When were you arrested?
31/6.
31/7.
31/7.
When?
When?
Nagaon. On my lord, 9th, my lord,
Seven, but
Huh?
7,
seven.
7 he wants.
Seven.
Several cases are fixed, perhaps, my lord.
Seven, we can adjust one or two.
Lord,
Because this is a case where the son-in-law is being harassed. Okay.
7.
List again on the 7th, allowing the learned APP to call for the case diary.
Obligation.
কোনটো 29 ৰ লগত কানেক্টেড 52 একেলগে মাতি দিব 29 আৰু 52 নাই কোনো হ'ব
May I please, Your Honor?
হুম
No, FIR is at page number 10, Your Honor.
Hmm.
May I read the FIR?
anticipatory bill
No, no, I'm not,
the child the wife died
yes, Your Honor, I'm not,
she vomited blood
no,
yes
you know, it is.
she died vomiting blood is it
No, no, you know. It's suicide, you know.
whatever be it she died vomiting blood
That, yes, you know.
so
You know,
unless you appear
my name is not there in the FIR, you know.
huh
I'm not projected as an accused in the FIR.
what
You know,
it is your wife
yes, you know, but I was out of station, you know, during this period, you know. You know,
Then-
see page number 13, you know.
who is the accused number 1 2 and 3 huh
Page number 13, point number 7, you know.
Hmm.
Accused number 1
What
is,
about the other two arrested
no, you know, one is arrested, Hussein Ahmed is arrested, you know. and
huh
Accused number 2 is absconding, you know.
then
I'm accused number 3, you know.
could not protect your wife inside your own home
You know, I was
yes when
Bengaluru, you know. was
CD when
Tribhumi, man. On 9th, man.
9th of September, a list again on the 9th of September, allowing the learned APP to call for the case diary.
Lord,
Mazhabla.
Yes.
May it please, Your Lordship.
Hmm.
Your Lordship, FIR at page 11 to 17.
Hmm.
My lord, 21, 30 cows, my lord.
30 cows.
My lord, vehicles were given on Zimma. Now, my lord, the owners of the vehicle, before your lordship, they are searching by police. So, my lord, at this stage, my lord, city will be called for by your lordship. And in the meantime, my lord, we may be protected. Because, my lord, entire case depends on materials. Cow seized, my lord, vehicle seized, vehicle given on Zimma.
And you do,
With the owner of the vehicle, my lord.
in one vehicle, how do you fit 30 cows
tickets.
No, my lord, 30 kettles, that
in one vehicle?
truck is big one, my lord. My lord, in that case, my lord,
16-wheeler.
my lord, your lordship will consider.
Huh.
There may be cruelty against cows.
Hmm.
If cruelty against cows, my lord, that will end it in fine.
Hmm?
Cruelty against cow, my lord, it is ended in fine. Some fine may be imposed. It is not criminal offense, my lord.
Okay.
My submission. And your lordship, vehicle seized, cows are seized, everything seized. And my humble submission before your lordship, the entire case depends on material evidence. So, my,
Yes,
my
sir.
humble submission before your
We'll allow him to appear.
in the main.
All the my lord, offences are non-bailable as per my lord.
My lord, non-bailable, that is why my lord.
Maybe let him appear.
My lord,
More than 30.
He will
cases.
produce the documents.
my lord.
You verify the documents, whether they belong to this particular cattle or not.
Sure.
Let us know. Vehicle have been given in Zimma.
My lord,
Cattle is with you.
yes.
Cattle, yes, cattle.
So all you need to do is identify the receipts and the cattle. Yes, if they do not match, then you would have further interrogation to do. If they match,
Yes, my lord.
then your into
Always it is 7.
Yes,
At
huh?
that time, my lord, they do not use, my lord, take the documents with their hand, my lord. Only
That-
after that, my lord.
that is why the verification part go and verify the
Yes,
receipts.
that is why, my lord, suppose only the
They-
vehicle was.
unless you have the receipts,
Lord.
unless they identify the market, will you be able to find out?
Mm.
Then they will come back with a statutory period over.
AB
because your investigation is not complete. Tell us. Huh?
He is not behind bars.
Hmm.
He is-
We'll just allow him to go and appear.
Yeah.
If you say that the receipts are not of the same cattle, we heard Mr. Sheikh Learned Counsel appearing for the petitioner also. Heard the Learned APP. Present petition emanates from an FIR. Now emanates from the Changsari PS case number so-and-so, registered under section so-and-so, read with Prevention of Cruelty, Animal Act, full stop. The petitioner claims to be the owner of the seized cattle, full stop. The Learned call for the case diary,
Not-
list again.
Not owner of cattle, my lord. We are owner of vehicle.
Owner of the vehicles involved in the transportation of the seized cattle. Full stop. Call for the case diary, list again on 17th.
No, sir.
17th of September 2026. In the meantime, the petitioner shall appear before the investigating officer on or before the 3rd of September 2026, along with all relevant materials, full stop. Both are owners.
No, owners. my lord.
There is one vehicle. How can there be two
Two
owners?
vehicles, my lord. One truck, one is Alto vehicle. Alto K10.
And so is escorting the vehicle and the truck
That
carrying
is
the.
elevation, escorting.
Drivers, I would not have considered. There is consciousness, but owners, we do not know.
Lord, my lord, I am to appear by
3rd of September 2026, on or
Alright.
before. In the meantime, in the event of their arrest, the petitioner shall be released on bail on furnishing bonds of rupees 10,000 each with one surety of the like amount to the satisfaction of the IO. Not even the cattle, they are the owners of the truck.
my lord.
My submission will be recorded regarding
The-
the carrying of cattle in cruel manner.
Before that you'll write, before I grant the bill, you'll write. The Learned APP has submitted that carrying of the cattle in a cruel manner would disentitle the petitioners from grant of bail, full stop. The Learned Counsel for the petition has submitted that cruelty to animals emanates only, would result only in a fine. And the custodial interrogation of the owners of the vehicle of the seized cattle, carrying the seized cattle may not be necessary at this time.
Oblige, your lordship.
Anticipatory bail application, your lordship. FIR at page 8, your lordship. Page 8 is the FIR, your lordship. Allegation is
CD when?
proposed to love. Allegation is proposed to love.
How much more do you need? You wanted a full penetrative assault?
My lord, I think POCSO
Huh?
will not attract in this case.
POCSO not attracted. Came to my home, caught hold of my daughter, kissed her.
My lord,
What more is required? We can reject it today.
Page 16, last
We
paragraph.
can reject it today. No anticipatory thing on this. You are
Page-
going to the house and doing things.
No, that is false allegation, your lord. Page 14 may kindly peruse, your lordship.
Page
Page
14.
14.
Yes.
14. This petition was submitted by the informant in the bail petition before the lower court, your lordship. Here, this is a file through special PP, your lordship. Here it is stated, my lord. Informant has no objection if the bail is,
Page 17.
my lord.
You need not read it. You can just read it for yourself.
So after,
Check another 183,
short date may be given.
Hmm?
Short date may be given.
A short date.
Notice has to.
We'll have it on 9th.
No.
List again on the 9th of September, full stop, since the matter involves the provisions of the POCSO Act. Issue notice on the respondent number 2 as per the prevalent notification. Petitioner to take steps during the course of the day. PP to call for the case diary. List again on the 9th of September 2026,
Oblige.
along with CD and report of service of notice on the respondent number 2.
Oblige.
Yes,
May I
sir.
please, Lordship, my lord?
Yes, sir.
This is my PA petition, my lord, and he is attending arrest in connection with my lord that Ramnagar PS case number 20 of 26, my lord.
Hmm.
The main accused, my lord, who is the son of the petitioner, my lord, he has been granted that my default bail, my lord. Bail, my lord, that order I have already next, my lord.
Oh, this is the one I confused with the other one.
My lord.
Yes, sir. We'll call for the case diary for the time being.
In the meantime, I may be protected, my lord, by
Sir,
granting at least, my lord.
we would
that
find
that,
it
my lord.
difficult. The allegations are too harsh.
No, my lord, she died, the daughter of this complainant died due to committing by blood vomiting, my lord.
So we do not know how it happened. It is within the.
But from the reflected from the affair, my lord, that is itself actually reflected, my lord. Is the false case implicated, my lord? Yeah, but this petition, the main.
You are appearing for whom?
My lord.
You are appearing for whom?
For the father of this, the accused number 1, my lord.
Govindo Das. Govindo Das.
Prohibitions, Das, my lord. The accused number 2, my lord, as per the.
You are accused number 2.
2, my lord. The one on, he has already been granted bail, my lord. That order is, my lord, you will also will find at page 23, my lord.
Page number 20.
23, my lord.
Default bill.
The default bail, my lord. So as the main accused has already been granted bail, my lord, by the court, my lord. Now the police is after the petitioner, my lord. He is the father of the petitioner, but the accused number 1, my lord.
Yes, sir. What do you say?
From the FIR, it reveals my lord, complication of the accused number 2 also, my lord. But kindly see page 16, my lord. My lord.
No, that I have seen. Now the accused number.
Hearing accused number 1, mother, and accused number 2 warned me, saying they will teach my daughter a lesson.
Yeah.
Yesterday, suddenly at about 3 p.m., my daughter called me over phone and that she is vomiting blood.
That is what.
I went to my husband's house.
And this is an incident of 33/2026.
My lord.
Yes, the medical report would have been there.
Medical report.
Can you find out about the status of the charge sheet as of today?
No.
We'll have it at 2. At 2, whether the charge sheet is submitted or not, have a telephonic instruction.
No.
And if for such a long period you have not been able to even file the charge sheet, we do not know.
No.
The other person has been given default bail.
All.
When you say the allegations are so serious, we expect the investigating authority also to take it seriously. Sir, can we have it at 2? Let him find out if the charge sheet has been submitted. Otherwise, we'll see what we can do. At 2.
Published, your lordship.
I'm being 6.
I'm sorry, my lord.
No issues, sir. Will you-
My lord, this is a 483 application. This is I take your lordship, page 18 is my first FIR, my lord. I lost against.
Now, which is the FIR now which you are
Yes, I'm coming.
paying for bail? Which is that FIR? It is the POCSO matter.
POCSO matter, but very interesting. After 1 year, 6 months, my lord, POCSO has been filed by one. Yeah. I take your lordship, page 52, my lord. Kindly come to.
Page 52.
Yes. Okay, next actually.
52 is. No, 52 is something which.
May I read, my lord?
52 I have read.
Yes.
I have read.
Yes.
In this 52 case, you are asking. Page 52.
Yes, but other cases in that court, another POCSO has been given against me. Then I have filed a writ petition. One after one other case, POCSO cases are coming against me. I am inside the jail. I do not know anything. But all these people are being done under the behest of the local political leader because I am a journalist. They have arrested me in one case. The Honorable High Court has granted me bail. I could not come out. They have filed one POCSO, another by Manasur. There is all old cases, referring to 1 year, 2 years old cases. That in a function, the journalist has touched my breast and belly.
Yes, you are not allowing someone to become Balmiki. Why? He wants to reform himself. You are not allowing him. Why?
My lord, moreover, my lord, when my lord, I am inside the jail, if any new cases are coming, I must be informed first.
At
That
the
is the
time
judgment of a
at the time of arrest.
Apex court.
At the time of arrest.
Yes.
Where is your order which took you into which showed you as arrested?
Yes.
In this case,
the IO has filed an application before the CGM to show me arrested, my lord.
Huh?
Well, my page 58, kindly.
58.
Yes. Case record is put up today, seen the written prayer of the IO, whereby she has prayed for aiding the section 65(1) of BNS, section 6 of the POCSO in this case. It is stated that victim was a minor girl, 17 years.
This is with regard to Lumding PS case number 91.
Yes, 91.
Where is Lumding PS case number 91?
91 number court is approved. Which is now we are paying bail in 91.
FIR 52, man.
FIR 52 I have submitted. She came from Dehradun to lodge the FIR. She got married.
No, she's 20.
One Priyanka Lama, my lord of Lamding. Presently address is Lamding. But she
No,
is-
prior to this 10/6/2026,
yes.
there must have been an order saying that you are shown arrested in this case.
This is the prayer. That is page 58.
No, they have, page 58, they have asked for adding of the sections. You must have been arrested in this case, shown arrested in this case.
Just a minute.
Is it not, Mr. Goswami? He is inside custody for some other case.
That FIR also, my lord, reveals, my lord, page 53.
My lord, page 47. Can I take your lordship?
He is currently in jail after long standing there.
Prayer to show arrest accused permission.
Where?
Accused. Page 47.
Ah,
91.
to show arrest.
Yes.
Now, where is that shown arrest? This was done on 17/6.
Yes.
Where is that order dated 17/6?
That is not there.
Huh?
Not there. Allow the investigating officer to show arrest accused number Arijit Das.
(19/6) order. There is a 19/6 order. Can you try and have that order?
19/6.
Page 62.
He is in district jail in connection with PS case 80/26.
Now, please come to page
62.
62. This starts at page 59. At page 62, he is in judicial custody in connection with this case since 19/6.
Where I was granted bail, my Honorable High Court.
This 19/6 order I want to see.
19/6 order is there.
If you are saying that he should have had
19/6.
given, he should be
Court order.
given that 48 and 47, tell us. 19/6 order, where is it?
এখানে এনএস করো না নাকি ওই কোর্টে তো করতো 19/6 19/6 order আছে ওই কোর্টে দেখছি আমি
No, it is not there in your list of the index.
it is there with me, man.
Hmm?
He was so arrest that is.
That is the order we want to see. If you are showing him arrest in some case, you must tell him that this is the case, this is the ground of your shown arrest.
Is the ground, my lord, so arrest, my lord?
এই orderটা কই গেলাম
It is on the strength of the warrant that has been getting the permission from the judicial magistrate, my lord. He was
19/6
Once the now the judicial magistrate is allowing the arrest,
doing the arrest.
he must be told the ground of arrest that we are also arresting you in this case also. Where is that?
Yes, my judicial magistrate, my lord, on the basis of the, my lord, materials on record, allowed the IO to, my lord.
He the judicial magistrate,
বেশি উদ্ধারে মারো তো এরকম
the person need not know what are the grounds of his arrest.
But not, my lord, like 47.
Not like 47, but that is why I want to see that,
Thus,
whether he was told
yes, that is a.
or whether seen the petition allowed the, cannot be. He must be told these are the grounds I want to have, they want to have arrest.
They have just forward.
The petition has to be given to him. He has to have a chance to reply to it.
Forwarding will be there, man.
Huh? That is.
Forwarding will be there.
this is the past Honorable High Court, man. Granting me bail, man. I could not give the bail bond. Immediately I was shown arrested. First POCSO by this Priyanka Lama. Then another POCSO by
We have asked for the order of 19/6.
Forwarding on.
19.6 by the
19.6. Yes, it is there, ma'am.
this has been
This is another one. Oh, for the first. Yes, I got 19.6 order. ma'am.
show us that quickly.
It is forwarding to Moto.
When he was shown rest, madam, that is.
Forwarding to Twitter.
Ah, tell us how
There
this
is no
possible.
forwarding because he's inside.
How is this possible? Tell us. देखो सुनते हो ना. When did he know that he was required to be arrested in this? No, no. On the next page, see on the next page.
Right.
Top line. Heard whom? IO. Seen whose petition? IO. When did he have the chance to say that I should not be arrested? Yes? Have your instructions? We'll take it up day after tomorrow. Mr. Goswami.
No, chief.
Mr. Viswas, kindly give him a copy of this. We'll take it up day after tomorrow. And bring this on record by an affidavit.
Sure. Similar order also passed in that court.
Are we, is my query clear?
No, sir. No, sir. No, sir.
When you move an application, when he moves an application, you get a copy?
No,
You
sir.
can resist it?
No.
Heard the IO, seen the petition, allowed?
No.
Ah. Not fair.
Well, I am apprehended, handling many more cases because I have filed a writ petition. They are prepared. The moment I will get a bail, they will file another POX or something. They are not able to put me under NSA because there is nothing anti-government. This is how the mouth of a journalist has been shut down by local MLA. Power is in their hand, what to do?
Unfortunately, we can only see what is there. in
Yeah,
the
exactly,
papers.
my lord.
Unfortunately. Otherwise, it would be a big. Yes.
Day after tomorrow.
Day after tomorrow,
I
at
will
the
give a
request of
copy.
the learned counsel, Mr. S.C. Biswas, to bring on record an order of the learned court below by way of an affidavit, and also allowing Mr. MP Goswami to have his instructions in the matter. Come on, list the matter again day after tomorrow.
For admission.
Maybe. At number item 2, Lady Person. Yes, madam. Item number 1. As quick as possible, you send it for the center. Yes, sir.
May it be the Lordship, here in this matter, my lord, the petitioners, they were convicted by the learned CGM, my lord, in GIA case number 1219 of 12, under section 149, 325 and 323. The appeal was preferred, my lord. Appeal was upheld only setting aside section 149. And conviction was for 2 years, my lord. Here, my lord, I am only on this case, my lord, before going, without going into the merit of the case, my lord, the whole case cocked up at that, because of at the time of immersion, idol immersion, my lord, Kali Puja Visarjan, my lord. They were local friends, my lord, some commotion took place and this marpit happened, my lord. Now,
Yes, Lordship, I'll leave it to Lordship because it's a 2000.
Shake your hands over the counter. Ask your clients to shake their hands and come back.
my lord, they have already, my lord, they have shaken their hands, my lord, they're living happily, my lord. Pre-conviction and post-conviction as well. They are still now of the same locality, my lord.
Sections 325 and 323.
323.
So,
Even, my lord, there were cross cases also. Those were settled at the Lok Adalat, my lord.
Yes, Lordship. Cross
Cases also, those were settled, my lord.
How do you overcome 325? Any period undergone in the during trial or during investigation anytime?
Previous, my lord,
Huh?
not arrested.
See, 325 does not allow it to be a simple fine. We cannot do it. So 325,
325, my
if
lord,
even 2 days of incarceration is there, we can say the period undergone. 320,
my lord,
huh?
in fact,
323, we
at
can
the time
say
of occurrence, my lord,
100 rupees fine and shut the matter.
at the time of occurrence, my lord, in the year 2012, 325, my lord, it was, can be compounded.
Where is the order of the trial court?
Trial court, my lord, your lordship will find, in page on page 23.
20.
Page 25, my lord, operative part, my lord, your lordship will find it, page 25.
PCR is here.
TCI is there, my lord.
That is option any kiba period undergo কৰিছে নেকি? You must have taken bail or something
My lord,
prior to this
Right.
thing. Can you find out
lordship, I'll
if he has if they've undergone
I'll-
any period of of this thing?
take the report.
Huh? Even a day would do. The hurt has been caused, is it not? There was hurt. So
Promotion and
we'll just try to bring it. We can dispose this of thing. Ah, you are Pannalal.
Pannalal,
And
Pannalal, my lord, Jawaharlal,
just a minute.
Kanu Devnath
Pannalal
and-
was arrested. Then
Kanu Devnath, Rupak
Kanu
Devnath,
Devnath was he arrested?
Panna Devnath and Jawaharlal, 5 people. 5 petitions.
Kindly find out and come back.
My lord,
Each of the appellants,
each of the appellant.
if they have undergone any period of incarceration, okay?
I'll-
এইটো অলপ পিছত মাতি দিব তেওঁলোকে ক'লে। এইটো নিয়ক, এইটো অৰিজিত দাস প্ৰেক্টিছ।
My appeal, Your Lordship.
Yes,
Herein, Your Lordship, I have filed this petition taking custody of the seized money, Your Lordship. In the FIR, Your Lordship, the Alice contraband was recovered from co-accused, Your Lordship. On the basis of a statement of the co-accused, the present petition has been implemented. And from his house, only rupees 2 lakhs and 1 pan card was seized, Your Lordship.
huh?
Only rupees 2 lakhs and pan card was seized.
That
And one
only
card-
should be after the money. 2 lakhs only was only 2 lakhs gives it a different impression.
Yes, no.
Hmm.
Page 21, Your Lordship, kindly see.
Page
What article
29.
was seized from the house of the page 21?
20?
What?
You've seen.
Cash money, thereafter pan card and one
Plastic polythene, yes.
But nothing was there. Inside the plastic polythene, there was nothing.
Yes, Mr. PP.
And the stage of
Let him give us surety and take the money.
Whatever that is, my lord,
Huh?
from the sale proceeds of the. that
We
is what-
understand. If that money could be confiscated if he's convicted, yes?
That is,
Now, till conviction, if he can be on bail, should he not be allowed to recycle, what do you say? To use the money End of the day, you find him innocent. His 2 lakhs is lying without any use. Huh? Let him give a guarantee.
Yeah,
He
bank-
gives a bank guarantee
Bank guarantee,
and he takes the 2 lakhs. Huh?
bank guarantee.
Yes.
Bank guarantee to be renewed, it's for 1 year. Bank guarantee is for 1 year. To be renewed as and when necessary.
Right.
To be renewed 1 month prior to the date of expiration of the bank guarantee during pendency of the case. That'll do.
That's it.
Suppose there is 2 years, he renews it 1 month before the date of expiry,
That's. Has to be.
or otherwise you invoke it
No.
to your treasury. Yes, sir.
But regarding bank guarantee, your lordship, I have no idea.
Find out. We'll take it
But-
after tomorrow. We'll have it at 2 if you want.
If your
We'll dispose this. We are not giving it to you just like that.
Yes. But what I'm suggesting is
Huh?
that your lordship, if your lordship personal bond is required, your lordship, then he's.
Nothing doing, not with this kind of people. Tomorrow you will come and say, I don't have the money, extend my custody by another 2 years. Where does how does this requirements of law of confiscation gets,
Okay, then your lordship.
if you have instructions from your client, a bank guarantee is nothing but the bank says that I'll pay if he doesn't pay. As simple as that. Have your instructions. If the bank guarantee thing works, then we can allow you to have the money.
Then at 2 your lordship then.
At 2.
In the meantime, I may be also allowed to check inside whether it is confiscation processing has been started.
Confiscation process.
Yeah. So my
Okay.
day after tomorrow.
Day after tomorrow. We'll have it day after
Then-
tomorrow.
Then I could.
But regarding
At the
confiscation,
at the
your lordship,
request, huh?
I have already got instruction, your lordship, nothing more.
His instructions could be different. Mr. Khan, learned counsel paying for the petitioner, who prays that the matter may be taken day after tomorrow for him to have instructions from his
126
client.
your
Full
lordship.
stop.
126, your lordship. 26, your lordship.
Huh?
Yes.
Day after tomorrow is 26th.
Okay, very good. Oh, yes. All right.
মই বেলেগকে থলো নেকি? আপুনি এইফালে আহিলে দিয়ে আপুনি মোক সেইফালে পাই দিলে। নহলে আপুনি কনফিউজ হ'ব। এইফালে দি থব বুজি লওক হা।
Wait, Bishop.
Bye bye, he will dig. Yes.
This is for quashing of the order taking cognizance, my lord.
Why?
Last, my contention, my lord, that there was no written agreement of cash transaction, my lord.
When?
Then, my lord, it was the cognizance taken beyond time, my lord. 130th B, my lord, cause of action arises, my lord, after serving of notice. Now, notice was not served upon me, and within that time period, notice has to be sent. That was also not taken, my lord, and these things are not followed, my lord.
We have filed an objection, my lord. I think it has come in the
The
record.
learned magistrate has passed an order, my lord.
Just
But-
cognizance was taken. He may take up all the pleas, the court below. He may take. If notice was served.
And the
not-
main
It was postal tracking I have given, my lord, it was served.
No, not served, my lord.
Wherever he goes.
That is the whole issue. The moment I start going into
Yes,
this factual part,
yes, Lord.
what was the trial court required to do? Nothing. We'll sit here and decide no.
No, only thing is that, my lord, they while taking cognizance, my lord,
Huh?
130th B, my lord, when the cause of action arises.
The
that
thing is
magistrate
that
has to see.
when the trial court takes cognizance, what does it mean?
Trial court
Have you
taking-
been charged?
No, no.
No.
It's a, my
It
lord,
says that it should be looked into.
check bounce.
This is a case I must look into. Go give your document. I was never served it. Matter ends.
But my contention, my lord, say abuse of process, my lord, say
How it
when
can
I
be
have
abuse
no
of process?
liability, my lord. I have stated that even bank has stopped the payment because I have nothing, we do not know. I have misplaced the checkbook also. When
My lord,
bank-
he said that, he said, she's my close relative.
These are things which the trial court is to consider. Should I consider it?
No, your lord. My lord, only thing is that whether it is barred by time or not, that
That is also
let the
considered by
magistrate
the court
decide, my
below.
lord, fresh. Cognizance, let the magistrate decide afresh.
What is cognizance?
Order
And
taking
what is
cognizance.
framing of charge? What is cognizance?
Cognizance by issuing process, my lord, before issuing.
Please come and tell me.
Yes,
This man says so.
yes.
Please tell me what do you want to say? You will file something. that I am not responsible, I did not receive the notice. Magistrate will look into it. No, I think you should be tried. Yes? Then the trial will start, or the magistrate will say, yes, I think you are correct. There should be no trial. I am dismissing this.
But since my lord, this NI
Why
case
should
is a-
I do it?
NI case is a summary procedure, my lord.
Am I, have you moved an application saying that, look, sir, this is the process, he has not done it, and then I will ask him to do it. But simply because you think that he should not have done it, am I supposed to sit here and give all sorts of direction to the trial court?
My
Why should I?
contention, my lord, this thing, let the magistrate decide, my lord, your lordship. may-
Oh, definitely he's under an obligation of law to decide.
A lady, my lord, whose checkbook is
Show me the law. I may be wrong. Show me the law.
138B, my lord, that within 15 days you have to issue notice, my lord, the complainant.
You show me the law that the magistrate was required to do this and he has not done it. He should have looked into the dates. He should have looked into everything before taking cognizance. He has not done it, sir.
That is itself the order itself, my lord. Last page, my
Oh.
lord, order taking cognizance. Order taking cognizance, my lord, reflect nothing, my lord.
Hmm.
Page 61, my lord.
61.
Yes, lord. Of my complaint petition. So criminal petition. Last page. ma'am.
Issue summons.
Complainant Moinuddin is present and he has submitted his initial statement before the court on affidavit under section 145. Heard learned counsel for the complainant. After perusal of affidavit of the complainant.
Of the
photocopies
affidavit, the photocopy of the document,
As well as.
content of the
content.
complaint petition, prima facie material,
facie.
therefore, ask him to come and have his say.
Now, even then, now the stage is still for appearance, my lord. Now that has not come, my lord. Earlier, the court directed, Honorable High Court directed, you file an exemption petition. Next
Did
day,
you?
sir. Yes, yes, my lord. Now, next that is yet to come in September, my lord. Now the thing is that, my lord, if I am innocent, my lord, and there is statutory bar for taking cognizance, let the magistrate decide it, my lord, discuss in the cognizance order, my lord, in detail. If it is statutory bar, then, my lord, it has to be, my lord.
It will be.
The Supreme Court judgment says, my lord,
After their apparent.
What does the Supreme Court judgment say?
this one judgment, my lord. Page 4, your lordship. Page 4, your lordship, paragraph 13, Roman 5.
Page 4, huh?
Yes, 44. Roman 5, my lord. The payee or the holder in due course of the check makes a demand for the payment of the said amount of money by giving a notice in writing to a lawyer of the check within
Please show
15
us your
days.
complaint. Is it annexed here?
No.
Your complaint, is it annexed in this?
I have annexed, my lord. Page
Yes.
23. Page 23, my lord.
This is the summon, my lord. Page 22, summon.
26.
That is the complaint petition, my lord.
At para 8, you have said that the notice was returned back to you.
Yes, lordship. Paragraph 8.
Page 26, para 8.
The postal authority attempted to serve the said registered letter containing the said legal notice 14th October 25 on 25/10. But the accused hides herself for avoiding to receive the accepted registered notice. Accordingly, postal authority returns back the said registered letter to the engaged lawyer of the complaint with an endorsement addressee out of station. Photocopy both sides. This
We'll have it on Thursday. Thursday class. On Thursday. You give us a judgment saying that if the addressee is out of station, it cannot proceed. You give us a judgment saying that if you have sent it to the correct address,
Yes, yes. It
but
is
she
correct
was not available, yet you can proceed.
Obvious.
And the
Whoever brings a
statutory
judgment
period-
gets the order, huh?
Statutory period of issuing notice has been
Whatever be it, get your judgment
on Thursday, my lord.
on Thursday.
Well, I pray to let it come on Monday.
Monday, next Monday, video. At the request of Mr. S.C. Biswas, Learned Counsel appearing for the respondent, list the matter on Monday. Full stop, both the councils have, shall be prepared with the relevant judgments on the said day. Etu kiman? Item 16, yes, 16.
Zimma pair of a vehicle was rejected by the landed court below Lordship.
Your Zimma.
Zimma Lordship,
Ah.
against the order Lordship. And impugn order your Lordship will find a page 16 Lordship. Page number 16 is the impugn order Lordship.
6.
1/6 Lordship.
1/6. A report was called from, that is not received today. That is.
Last 4 months, Lordship, the vehicle was lying outside the police station Lordship. Against the Sundara Ambalal case Lordship.
See, abdominal distension, respiratory distress and restlessness. How many cattle in the vehicle?
39.
The kettle is different, Lordship, the kettle was given to the Zimma to the owner Lordship. Subsequent.
No, 39 cattle in one vehicle.
No, Lordship, what happened Lordship in this case Lordship, the vehicle was given a higher agreement to one observed hawk, which I have the agreement.
When are you getting the report, sir?
That, on 3rd May.
3rd of
The
September.
last 4 months Lordship, the vehicle was lying.
See, the
What
report,
happened?
the report
Yes.
can be had here on the net.
Yes.
Yes?
In mobile Lordship.
When was the vehicle confiscated
it is not confiscated,
Vehicle was seized, my lord, on
or seized?
It was
342026,
3/4.
along with the cattle. 6 months, not a report from the DTO.
No, it was, then my lord, 16/5, it was moved before the
Huh?
trial court. my lord.
Where it was said that the verification of chassis and engine number is pending.
Yes. It was 25/6.
If the insurance is getting over or the vehicle makes an accident, it is a matter of 3 minutes to get the chassis number and vehicle number verified.
I have also annexed the vehicle registration certificate, livestock vehicle Lordship. It's meant for the construction of the livestock.
3rd, Mr. Goswami kindly, on 3rd, have the report.
No, sir.
Allowing the vehicle to be installed there is not helping anyone. On the list again on the 3rd of September 2026 to enable the learned APP to make available the report which was earlier called for. Full stop. It is noticed that the vehicle had been seized in the month of May and the report is not yet available in the month of August 2026. Full stop. It is made clear that no further time may be granted on the failure to furnish the report on the next date fixed, and the matter may be taken up for adjudication on the basis of materials available on record.
Please, my lord.
Hmm.
My lord, I'm challenging lordship. The cancellation for bail ordered dated 3/4/2000.
You are praying for cancellation of bail.
Bail, yes.
Why?
Learned court below, page 33, lordship.
Hmm.
This is the order, lordship, learned court below order, lordship.
Yes, sir.
Yes, I am respondent number 2. So I want to file written objection.
Huh?
I want to file written objection.
I think we should bring in the Pharmacy Council of India here also. Are you authorized to administer such injections? Hmm? This matter was
I have got bail. And one petition has been filed by the petitioner in the session court that has been also rejected.
rejected, yes.
I have not violated any terms and condition of my bail.
Of what? Of the bail.
So that is written on the order para 27. my lord.
Where is that? Oh, no, what were the conditions of bail? Show us that. What is the, where is the bail order of the High Court?
Or notes, page lordship, 59 lordship,
Page?
page 59 lordship.
Page 59.
Page 72, Lordship, page 72, paragraph number 19, Lordship. The learned court below not considered this paragraph, Lordship. It is clearly mentioned, Lordship.
File your objections,
Yes, ma'am.
Mr. Goswami.
And with all aspect, in the meantime, Lordship, CD may be required, Lordship, case that may be called for.
We are following for something. This man was arrested. The respondent number 2 was arrested because he had been administering injections to persons, and now people are. There are earlier 2 occasions
Correct, Lordship.
when he
But
was
according to
arrested
the
on a
itself
similar
mentioned,
offense,
Lordship.
when there are similar complaints. Now he says that he has not violated any terms and conditions of the bail, so therefore this petition can be rejected.
That has been already.
We'll call for a report. You will have it on the 9th of September. During that time, call for the case, have the updated status of the investigation on this case, and further specific instruction as to whether this man has been attending 3 things. 1, whether he has appeared in the NEET examination 2026, he being 33-year-old.
Yes, correct, Lordship.
Has he appeared in that examination? Yes, you are supposed to appear in that examination.
Yes, ma'am.
Has he appeared at all in that examination? Number 1. Number 2, whether he is still running the pharmacy. And number 3, whether he has been administering injections beyond what he is licensed to do. I think pharmacists to some extent can administer intramuscular and all that. Can he administer intravenous, and has he been administering such medicines after he has been released on bail? I have a report on that on the 9th or when? So 14th. 14th of September. Heard Mr. So-and-so learned counsel preparing for the petitioner. Also heard Mr.
Yeah, ma'am.
Ahmad learned counsel appearing for the respondent number 2, who prays for some time to file his objections in the matter. List again,
3 weeks time.
list again on the 14th of September 2026. The full stop. The respondent number 2 may file his objections in the meantime. Full stop. The learned APP shall have necessary updates on the stage of investigation in the connected FIR, and shall also have specific instructions as to whether the respondent number 2 had appeared in the NEET examinations 2026. Comma, whether the respondent number 2 has been continuing to function the pharmacy. And number 3, whether the respondent number 2 has indulged in administering medicine to patients beyond what he is licensed to do. Full stop. These information are being sought for since it has been observed from the forwarding of the respondent number 2 that in earlier instances also similar malpractice had been resorted to by the petitioner. Full stop. The learned counsel for the respondent number 2 has submitted that the petitioner has not violated any terms of bail and has not indulged in any illegal activities after he has been granted bail. Full stop. List again on 14.9 as a proceeding.
The rejection also mentioned. Of the session code.
What?
The terms and condition has not violated. Page number
We'll
17.
see. We'll see the exact terms and conditions. You wanted to appear in the NET examinations, did you?
Deeply of this, Lordship.
Iman?
Yes, please, Your Honor. Yeah, my lord, the petitioner was arrested on 16/3/2026. As on date
16-3.
16/3/2026. As on date, he has completed 162 days in the custody. My lord, may kindly come, recover his lordship,
Page 19.
no, lordship may kindly come to page number 24, the season. Yeah, lord,
Ah.
I'm taking the specific ground of non-compliance of section 50. My lord, may kindly come to page number 24, the Caesar.
Hmm.
Second paragraph. I so and so, so and so, so and so do hereby search the vehicle slash auto, comma, body and belongings of Noor Ahmed, so and so, so and so, and Zakir Hussain. Your lordship, Noor Ahmed is the present petition. Now, my lord, may kindly come to page number 36.
36.
36. The notice, lordship, which was
Just a minute.
issued under.
Page
Page
36.
36, my lord. This is the notice, lordship, issued under section 50 of the NPA.
Hmm.
To Noor Ahmed, that is the petitioner, sir. Whereas there is a reason to believe that narcotic drugs, psychotropic substance, controlled substance, so and so, so and so, things which may furnish evidence of commission of an.
Yes, sir. Already this has been discussed in other judgments,
Lordship,
other bail petitions.
section.
Hmm?
Now, my lord, here, my lord, section 50 notice is highest, my lord. The price, my lord, lordship may kindly say he was given a this and
Hmm?
written notice was given and also, my lord, just put his signature, my lord.
Hmm.
My lord,
I require, I do not require,
Neither-
neither is ticked.
Nothing. Lordship. That
Not
is my-
ticked.
Lordship,
I require or do not require.
I do not require that.
So that part is gone, his signature part is gone. Number one. Number two, you say that I will be, the notice says that your personnel search will be conducted by me. Do you need a gazetted officer
No,
or a magistrate?
no, sir.
That is not the way. You have to inform him, you can refuse to be searched in their absence.
The Caesar part, my lord, may kindly.
I searched his body. Otherwise, by the 50 notice.
On the rear seat of the, my lord, in a bag, my lord, the contraband was found.
But you searched his body.
First is, but it was not found anything.
That has also been settled.
Yes,
Not
Lord.
found anything.
That has also been
That
settled.
is also.
We can record your submissions on all this, but it has already been settled. Would any meaning lie out of it?
Then after that, my lord,
I think the apex court has said that if even if the recovery is from outside the body, but once you search the body,
Yes, Lord.
the arrest goes, whether recovery made or not. Correct us if we are wrong.
that is law, that is law, my lord, I cannot say what to be.
I'm ready to go by the new law every time you
Lord.
tell us, no difficulty.
My lord, regarding this notice part, my lord, I just want to have one, my lord, or have an opportunity regarding the whether. that-
2 o'clock.
That,
2 o'clock.
no, not 2 o'clock.
Bail. Man is behind bars, liberty.
But
Someone
my
that
lord,
they
but
told
he
me,
is-
not 1 second more, sir. So
He is not.
I am
my lord,
afraid to give it for the next 2-3 days.
Because, my lord, he was caught with the, my lord, he was caught with the narcotics drugs, my lord.
Not from his body.
Not his from his body, but.
Now
from
you
his-
search
from
him.
his- From his position, my lord.
So you search him. Then what? What is the what is the condition of the position of the driver? Either it is from the conscious position of the driver or him.
Okay.
Oh,
And now
you say driver is consciously possessing it. Then how can he consciously possess it?
both are present. That
Joint position.
Joint position.
Then it is again a different story.
And joint position.
Then joint position, you have to prove another story.
Yes, ma'am.
It will complicate issues
Complicated issue, man.
for the
right
prosecution.
issue, that has to be in the form of.
Tomorrow.
trial.
Tomorrow?
Otherwise, my lord.
Tomorrow.
LCRs were called for lordship. That is.
He is reading
Yes,
it.
Lord.
It is with him.
LCR just time.
It is with him. We'll have it tomorrow. List again tomorrow, allowing the learned APP to have his instructions on the section 50 notice.
No,
served upon the petitioner, full stop. The same is is a part of the bail petition at page 36. Full stop. This court is of the prima facie view that the petitioner not having been given the option of refusing a search in the absence of the gazetted officer or magistrate, and further, when the notice does not record the statement of the petitioner that he had either required or did not require the presence of a gazetted officer or magistrate, comma, the arrest may have been rendered illegal, full stop. List on 25(8) as prayed for by the learned APP.
Not,
Highly obliged.
I'm obliged.
I think a week ago we have given an order
Yes,
on this exact very notice. I don't know,
last week.
Mr. who appeared, NJ. Forget who appeared.
Last week.
Last week I've given 2 orders on section 50 notice. One was those small kids who were carrying the drug and they were searched.
On this directly compared.
Ah, from the pocket, one lady was there and this one was there. Yes, sir. Where is your section 50 notice?
My lord, my section 50 notice is perhaps in the LCR.
Not here.
PCR, sorry.
But
Not
in
here.
this case, one instruction was supposed to be taken, my lord.
Yes.
But that instruction I have not yet received because my lord, police already filed a search sheet.
That is what I,
That record was not with them, my lord.
Mm.
So, what date may be given, my lord?
my lord, what I am, because once the charge sheet is filed, my lord, in my limited understanding, police cannot furnish any such instruction as on date.
What was the instruction?
The instruction is this. Kindly come to the arrest memo. That is at page number 16. My lord is there at page 16. My lord will see who has attested this. One Deep Das and one Deep Jyoti Das.
Ah.
Now, my lord may kindly come to page number 20. This is the charge sheet. Column number 12, particular of witnesses. My lord is there. Page 20, which is a part of the charge sheet. Column number 12, particulars and date of list of witnesses. Have seen that? Page number 20. Down below, column number 12, particulars of witnesses cited, stroke relied upon.
Permanent address with Aadhaar statement recorded, types of evidence, occupation. Ah, yes.
Particulars of witnesses cited and relied
You are
upon.
saying column number 12.
Yes.
It is serial number
Serial
12.
number 12.
No, I was counting those columns.
column.
They were not 12. Yes, Mr. So-and-so.
I
Mr.
don't find
So-and-so.
the names of these two persons. Now, whether these two are some fictitious person, who are these two persons?
No, they were there only at the time of your arrest. Why should they be named as witnesses to the incident?
They
itself?
are, they are the,
Caesar witnesses.
in my respectful submission,
They are Caesar
they-
witnesses.
no, my lord, they have made somebody else's, this is where the prejudice have caused. My lord, I am arrested for being possessing certain alleged certain contrabands, my lord. My arrest is witnessed by two persons who are missing from the entire list of witnesses. So whether I was actually arrested on that day, on that time, who will testify that? It is they who will testify that yes, this gentleman on such and such date at such and such time
That is
was
why,
arrested.
that is why we had asked him the query as to who are these two persons.
My lord,
They are not required for your trial, sir. They are only required to answer
yes,
whether your arrest was correct or not.
correct. Lord. Now, my lord, what I am submitting is that because he said that the recorder here. Now, my lord, assuming, my lord, they come up with two Jyoti Das and this Das, my lord. If those two names does not figure out in the papers which has been supplied to us under 207 of the CRPC and which are a part of the record, will this court take cognizance of that?
That is what he's asking time for to have his instructions on this. That is what you had asked for.
Yes, ma'am.
That is
He is
what,
asking to have instruction from the police, rather, my lord, to whatever I understand.
since the documents are already in this
Yeah.
court or it was in that court,
Yes.
he has to tell the police that this is the document I find on record. What is your say in it? Do these persons exist at all? Do you have any record of these persons at all? That is what he has to ask.
Because, my lord, yes, my lord, whatever has fallen from your lordship, I am not arguing to that extent, because what I am, my lord, what I am submitting is that can be very well, my lord, the learned public prosecutor may go through that TCR, whether there is any reference, whether there is any mention in the TCR.
We'll have it day after tomorrow. Can you find out?
My lord.
Day after
And
tomorrow.
can I, my lord, go through the TCR once, my lord? And if
List again on 26th of August at the request of the learned APP. List of the learned counsel for the petitioner has sought permission to go through the TCR, same is allowed. Yes, next matter.
Wait, please, Your
Hmm.
Honor. We have also noticed that 48 notice was not served to the family members. That is my,
Whom did you nominate?
notice.
Whom did you nominate, sir?
That is also not reflected here. Lordship may kindly see that.
You
WP
tell
was
us.
at Page 24.
You tell us that on oath you had nominated this person.
In forwarding report, it is said, Lordship, their family members, guardians have been informed as per section 48B and page 18, Lordship.
Huh?
Page 18. So he has.
Page 18.
Yes, he has probably nominated his family members. Compliance with BNSS, that part Lordship will find.
Yes, sir. Have you gone through this? Any 48 notice
Page,
with signatures and all?
page 24.
Page 20?
24. It is
Four.
a WT message, Lordship.
Hmm.
message is there.
Hmm. WT message to whom?
To the officer in charge.
Khagaria. So any report from Khagaria?
Not any. No any report.
Any follow-up?
My lord, here is email also sent, my lord.
Any follow-up whether a notice has been received or not? Did you try to follow up the case to see whether notice had been received or not? No. We'll direct a disciplinary proceeding against this person.
I'll have to again go through, my lord. This is original.
I will direct a disciplinary proceeding against this Brochuk police station.
I'll have to again.
Why is there no follow-up?
I'll have to go through again, my lord.
Suppose we grant the bail. 10 days later, the Khagaria says that this is not a correct address, such place does not exist, such man does not exist.
I'll take
This is a fake thing.
My lord. My lord,
Yes?
I'll
Then the 48 notice becomes useless.
well, I'll take instruction from the Gorsuk Kosi, my
Now,
lord.
why it was not followed up?
My lord, whether it is followed or not, my lord.
When? Today, too,
Day after tomorrow, my lord.
tomorrow, at best. Personal liberty, what to do? Day after tomorrow. We'll have it day after tomorrow. Have you? Day after. The learned counsel for the learned APP has submitted that though there is though the notices to the family of the petitioner had been sent by WT message, comma, there is no instruction as to whether the same had actually been delivered to the family of the petitioners, full stop. The learned APP has sought for accommodation to verify as to whether any follow-up action after sending of the WT message had been taken up by the officer in charge of the police station and or the investigating officer, and to inform this court as to why, and to inform this court, comma, in the event no follow-up action was taken, comma, why such dereliction of procedural follow-up had been resorted to in this case.
And one prayer, Lordship, one observation maybe there that if they have taken a follow-up action, whether it was intimated to the court while filing charge sheet or not, that aspect, Lordship, may kindly look into.
If they have taken, if they have informed you, matter stands closed there. If they have not informed your family,
Because they may have produced some document now, Lordship, which was
with
not
a signature of
to the
with a signature of some person,
Lordship.
which will make the arrest legal
Lordship.
without any flaw, and therefore that 48 ground goes. Whatever next ground you want to take up, we'll hear it when you take it up.
On that day, I will
Is it not?
On that day, I will submit, Lordship.
Today we are on the 48. Any other ground which, barring 48 also, we can grant you bail, show us, we'll consider it.
Lordship. Oblige.
আর ওটা খুব কারেকশন করি আনি তুমি দিব ওয়ান্স বেলেগ বেঞ্চে মই দিব যেটা কারেকশন করব ইয়েস 81
May I please, your Lordship? Lordship, in this case, Lordship, I have taken the ground of 24 hours, Lordship. I have checked the TCR, Lordship. Only difference is what I found is like 35 to 40 minutes. So, Lordship, may I pray that Lordship may kindly fix this case, Lordship, day after tomorrow, Lordship.
at the request of the learned counsel for the petitioner, list again on 26th of August 2026. We'll have it on 27th of August.
Highly obliged.
Here in this case, FIR, your Lordship will find page 15, Lordship. The petitioner was arrested on the basis of co-accused statement, Lordship. And whether they have found any material to connect me with the said contraband, Lordship, after conducting investigation or not, that your Lordship may kindly see, Lordship. Page 15 is the FIR. Only one aspect, Lordship may kindly consider.
But I want to go to the TCR once again after some time.
After some time? After some time, Paribo? After some time.
Okay.
Day. Itu file release করে দিব কোনখানে 1 নম্বর আইটেম তো কোনখানে রিলিজ করে দিব উঠিয়ে দিব 24 26 yes ma'am.
Dr. Mayor, please, your Lordship. Lordship, the case of the petitioner is that the complainant visited one dhaba located at Rangia, namely Rutramani Dhaba, wherein the owner, namely Joinul, and on getting to see hanging of some Hindu deities there, the complainant got enraged, and thereafter they both entered into an altercation, which ultimately led the complainant to lodge an FIR stating that he was being assaulted by the owner along with some other accomplices of the owner who happens to be the staff or his friends. Now, Lordship, here I am not the owner, not the accompanied staff of that particular dhaba. I have been picked up from my home after 2 days of the alleged incident.
You are
As per the
Imran Ali.
formatting. And considering which, Lordship, the Honorable Coordinate Bench was very pleased to grant me interim bail, considering the ground of allegation in the alleged FIR. And the CD is there, Lordship, and interim. And already I have undergone 30 days of incarceration. Considering which, Lordship, and I am duly cooperating.
My lord, here we have received the case there, my lord, without the medical report, my lord. Today,
Let us say the hurt is there.
today I have informed, talked to OC, my lord, in IO, my lord, he said that medical report collected, my lord. And here, my lord, second item.
That be so. Then when? Day after tomorrow.
My lord, Thursday, my lord.
Thursday we'll have it.
Interim, my lord, all.
You are on interim.
Yes.
Let him have the satisfaction of a medical
Medical report, my lord.
report, although the interim was granted without the medical report,
Yes.
assuming that the injuries are there, whether you require a further custodial interrogation, medical injuries will show you whether any further custodial interrogation is necessary, possibly not. Medical report cannot show you.
But we.
In case of a death, unnatural death, or who hit him, whom with what, in that case, your medical report is required. In this type of cases, is it required actually? Heard Miss
Albany.
Learned Counsel appearing for the petitioner. And also heard Mr. Sharma, Learned Counsel, Learned APP, full stop. The Learned APP has sought for an accommodation till 27/8/2026 to produce the medical report. Full stop, allowing the accommodation list on 27/8. In the meantime, earlier term protection granted shall continue.
So I am for
25 also there, my lord.
24, 25, 26.
25, my lord, his statement is not available in the case record.
Have it before he's on interim.
Yes, sir.
Either tell us that he has not appeared, we'll recall it, he has appeared, we allow it.
Right.
You are in item?
Lordship 25, Lordship.
Has he appeared?
Yes, Lordship.
Once the interim is there, unless you show us that there is something more you require. Yes, next.
May I please, your lordship? Regular bail application, petitioner was arrested on 22/5/2026 on DPS Act, and C is also involved, the contraband, there is seized was 197 number of Yaba tablets, along with heroin, which is 29 point, that is intermediate quantity, and the Yaba tablet that come on weight, it was comes commercial quantity, madam. Now the 95 crore is that there. My first submission is that, my lordship, the petitioner, nothing was recovered from them. They were not present at the spot when the LS contrabands were seized from the house of another accused, Rabiul Islam, who has already been arrested along with his employee also, Safiul Islam. Both are now, these two petitioners have been arrested subsequently on the basis of the statements of the co-accused, my lord. That they used to come and purchase contraband drugs from us. That is the material that is coming against them, my lord. Except that co-accused statement, there is nothing to connect them with the instant case, my lord. That is the only thing. And the search is submitted now, but still, the search is submitted during pendency of this petition. Earlier, during investigation, I have come, and on last occasion, the court wanted to see if there is anything materials to connect them with the case. Otherwise, court was inclined.
So we can only call for the PCR, or you may approach the PCR.
PCR will also may call that in the case, because
Mr.
already 95.
Sharma, Learned Counsel, Learned APP has submitted that the investigation has culminated in charge sheet number
238 of 26, dated 12/8.
2026 full stop. Learned Counsel prays for a perusal of the scan copy of the TCR. Accordingly, call for the scan copy of the TCR. List again on 11th
11th of month.
September. Oh, no, not 11, not 11, 10th. 10th of September.
Borpet, I can earlier that already is.
We also have to look at the number of cases we have been
Sure.
fixing throughout the week.
I'm sure.
Huh?
Well,
we have preponed your case from 11th to 10th because 11th is full, 10th we had 1 day left.
on 10th.
On 10th of September.
Okay.
Yes, madam.
May I please, your lordship? This is an application under 483 of the BNSS for release.
Respondent number 2.
Respondent number 2 has not, service is complete, lordship, as per the office note.
Service
but
complete.
Service is complete, but amicus may be appointed.
B, where is flag B? Eh? Flag B. এইটো ফ্লেগ বি কোঠে এইখন চিফ জুডিশিয়াল মেজিস্ট্রেট
Notice has
After-
been received, Lordship.
after all our precautions, the CGM takes a photo of the informant and sends it with the record. What about the identification of the, what remains for identification of the victim or the informant? Hmm? So what do you do? Will appoint an amicus?
Whether service complete or not.
With photograph complete. Holding the notice,
Yes.
photograph is there. You can have a look if you want to.
Right.
As per the office note dated so and so, and the connected notice received from the Chief Judicial Magistrate Nagaon, Assam, the service of notice on the respondent number 2/informant is complete. Full stop. None appears for the respondent number 2 today. Full stop. In these circumstances, this court appoints whom? Listখন আছে নেকি? এই legal aid listখন? Amicus legal aid? Appoints so and so নামটো এটা খালি রাখক so and so as the amicus full stop the learned counsel for the petitioner shall serve a copy. M.K. Brown did you Miss M.K. Brown learned counsel as the amicus to defend the interest of the informant and the victim in the present case full stop. Learned counsel for the petitioner to serve a copy of the petition upon the learned amicus during the course of the day. Full stop. It is provided that in the event respondent number 2 enters appearance, the same shall also be allowed. Full stop. List again on 28th of August 2026 for consideration. You have received the CD, sir? The CD has been received by the learned APP.
Lordship, a date may be fixed.
28.
20th.
Timing 22.
The FIR your lordship will find page 15.
50.
15. Here, lordship, in the first paragraph, I'm pointing out two things. They said, lordship, they conducted one surprise NACA checking. That part your lordship may kindly note. And second thing, that lordship co-accused stated that I was in the bike and I fled away noticing the police. But none of the police witnesses say that I fled away from the place of occurrence. It is only the co-accused statement. Now, if I may take your lordship to the charge sheet at page 25. This is
Yes.
the summary of the investigation, lordship, during investigation. Here nowhere mentioned that I fled away from the place. And only implication that your lordship will find page 26.
What about the pre-page last line? You are
page
named.
Name.
Yes.
Page 26, after result of examination, that 2 lines here lordship will find several attempts were made to arrest the other FIR named accused person, namely Hilaluddin. Also searched the house of accused person, prepared house search list. Later on, he was arrested. So after that, what material they have found, there is nothing on record, lordship, that I was connected with the case. Because apart from that co-accused statement, there has to be some material to connect me with the crime, lordship. And because co-accused statement, he is not a witness in the present case, so his statement will not be there for any help for the prosecution side.
My lord, here along with the statement, the statement of the other accused, the petition, he also stated that my lord, after apprehending him, my lord, that he was with him, my lord. He is seeing the police.
It is charge sheeted.
Charge sheeted, my lord.
That statement cannot be used against him
But that
to
cannot
prove
be
his guilt. No, this is only prima facie.
used.
So he may have some scope of innocence. Now tell us on the other part of 37 that he will not do it again. Has he been found to be doing it at a previous point of time?
My lord, that is the
Any, so you don't have that information today. So as of today, we have to assume that he can be restrained with proper conditions being imposed upon him.
The other aspect is that, my lord, since it is a commercial quantity, my lord, because.
That is why we have
are-
asked you the two
yes, my lord,
questions.
the commercial quantity.
Ah.
But the thing is that it seems they were acting as a group, my lord.
Seems from where?
My lord, because both stated that they are together. My lord. That cannot be used. That cannot be used.
This statement can the trial court listen to? It will not even be taken on any ground. So when were you arrested? 1905? No,
1912.
1912 2025, sir.
25.
Two grounds. If we find a second case against him, we'll note in the order that in the event of a second case against him, you'll be entitled to pay for a cancellation or recall. Or even if you find out an older case against him, you can still bring it to a notice.
My lord. At this moment, I have
Nothing there. So continued custody at this point may not be. Yes? Heard, Mr. Ahmad Learned Counsel appearing for the petitioner also heard the learned APP, full stop. The scan copy of the case records of NDPS case number 04 of 2026 have been received and the learned APP has gone to the same, full stop. The learned counsel for the petitioner has submitted that it is only on the basis of the statement of the co-accused during police interrogation that the petitioner had been arrested 2 days after the alleged recovery of contraband from the co-accused. Full stop. The learned counsel for the petitioner has drawn attention of this court to the charge sheet.
He was arrested after about 3 months, more than 3 months.
After about 2 days, no, after about 3 months, after more than 3 months, to the charge sheet to indicate that there is nothing in the charge sheet which would which would bring on any implication on the petitioner herein, full stop. The learned counsel has submitted that the petitioner has been in custody since 1912-2025 and there being nothing on record in the charge sheet, etc., to show his involvement in the business of contraband, etc., this court may presume that the petitioner petitioner may be able to prove his innocence during the trial proceedings, full stop. The learned counsel for the petitioner has further submitted that there is no past history of the petitioner being involved in the business of contrabands being brought on record, and therefore this court may also take into consideration the fact that the petitioner undertakes not to be involved in any transaction of any contraband in the future, full stop. He accordingly prays that the bail petition may be considered, full stop. Learned APP has submitted that the statement of the co-accused had led to the arrest of the petitioner, and since it involves commercial quantity, release of the petitioner at this stage may hamper or temper the trial, full stop. The said, in the opinion of this court, can be taken care of by imposing the strict conditions upon the petitioner for his participation during the trial, full stop. Accordingly, it is directed that the petitioner, namely so-and-so, shall be released on bail in connection with
Special NDPS case number 4 of 2026.
pending in the court of the
Special Judge Sri Bhumi.
Sri Bhumi. on his furnishing a bond of rupees 50,000 with two sureties of like amount, one of whom shall be a local surety, to the satisfaction of the learned trial court, full stop. It is further provided that the petitioner shall not involve in any offense during dependency of the trial, no, any offense in the future of similar nature, and in the event the prosecution in the event of the petitioner failing to conform to the conditions of bail imposed, the prosecution shall be at liberty to bring the same to the notice of the learned trial court and pray for recall of the bail, full stop. The learned trial court shall be at liberty to impose such other conditions as may be deemed necessary to ensure the participation of the petitioner in the trial proceedings. Bail application accordingly disposed of.
Obliged.
Lead you. One to lead you. Yes, what is the mistake?
But in order dated 28/2026, paragraph number 5, my lord.
Paragraph number
5.
Yes.
The name of PS Boganodi.
Huh.
It should be Hazu. Boginodi should be Hazu.
Kindly show it to the PP. The bail petition and both.
Yes, right.
It have been Hazu.
Will allow the correction. Heard Mr. H. Ahmed and counsel paying for the petitioner and Mr. R. Kaushik learned EPP, full stop. The petitioner has submitted that the petitioner was approached this court praying for grant of pre-arrest bail in connection with Hajo PS case number 370 of 2026. Full stop. While this court had granted bail on an interim protection on 28/2026, although the PS case number was correctly noted in paragraph 2, in paragraph 5, inadvertently the word Boginodi PS has appeared, full stop. The learned counsel for the Boginodi PS has appeared for the petitioner to cooperate in the investigation by appearing before the investigating authority, full stop. Accordingly, he has prayed for correction of the typographical error, full stop. The learned APP has gone through the order and the records and has submitted that the correction would not materially affect the intent of the bail granted by this court. Accordingly, it is directed that the word Boginodi PS appearing at paragraph 5 of the order dated 28/2026 shall be read as the Hajo PS in all further references, full stop. The correction in the order dated 28/2026 is accordingly allowed on the mentioning of the learned counsel for the petitioner. List this matter again on 9/9/2026 as fixed earlier. Yes.
May I please your lordship?
Hmm.
FIR is at page number 16, operative portion, page number 16.
16.
16. The brief facts of the case, your lordship. It is of NDPS Act. One, from reliable sources, police got information that some loading of contraband substances were taking place at the house of one of the accused, namely Anil Bora. They reached the place, and accordingly, section 41, subclause 2, this authorization was issued, and thereafter, your lordship, they entered the house. They found 6 persons and contraband substances hidden beneath the bed. Moreover, there were 3 vehicles, one of the owner of the house and other 2 vehicles parked near there, and they found some contraband also in the cars.
Okay.
3 cars. This is the case, your lordship. Now coming straight to the submission, Your Lordship, my first ground is that there is a discrepancy in the timeline. As per the FIR, Your Lordships, they've categorically stated that at 4 AM, they received the information. Then, Your Lordship, I would like to take you to the seizure list, that is page number 32.
Just a minute, just a minute. Where is the scissor list?
Seizure list, page number 32.
30.
332. Sorry.
Yes.
The time of the seizure is 7 AM. And then I take you to take your lordships to the FIR again, page number 16.
They received
Page
information
number
at
17.
4 AM. Caesar is at 7 AM.
7.
Okay.
And then page number 17, 17. After all the completion of the legal formalities, the police party departed from the place of occurrence and arrived at the Bonga outpost at 11:30. Now, Your Lordship, the interesting part, page number 23. There is the 36 notice being served upon me. There, page operative portion, page number 24, Your Lordship. Place of arrest, Majuli PS. And date and time of arrest, 2/5/26 at 10 PM.
Night.
47 notice also says the same. And Your Lordship, 48 notice was not served to me, my family members on the date of arrest.
Whom did you nominate? Whom did you nominate?
I did not nominate anybody, Your
Then
Lordship.
how can they serve if you not
No,
nominate?
I have informed them. I have told them, I've given them the contact numbers of my parents, which were already there in my phone being seized by them. But what I'm saying is that, Your
You may have
Lordship,
given all the phone numbers, everything.
I've informed them that my parents are there, they can do, but they have not served the notice, Your Lordship. I take you back to section 36 notice.
No, where is that notice under 48? It has been given to one Deepika Burman.
Deepika Burman is my mother, Your Lordship, and she is the petitioner on affidavit.
You were arrested where?
I was there also, same, Your Lordship. Arrested
Majuli.
at Majuli PS.
And they are required to serve it at Nalbari.
Nalbari.
36, Where is that 36?
Now coming back to the 36 notice, page number 24, Your Lordships. The name and address of the witness to arrest is Bandita Soikia Bora, and she is the wife of the prime accused Anil Bora, from whose house the contraband substances were seized.
Does it mean she is not a respectable person who can?
Indeed, I want to establish that she is not a.
Oh, how?
Because her husband is alleged to have.
The husband is a criminal. Why should the wife be not respected? Respectable doesn't mean that I or you respect her. Respectable is she must have something which is to be respected. Husband being a drug, this thing, how? That is going to affect.
I leave it to Your Lordship. If Your Lordships consider her to be respectable, then
it would be a big thing. Otherwise,
I don't want to press that. If Your Lordship
let it go for the time being.
Your Lordships, my basic contention is that the accused person was detained for more than 24 hours. I mean,
when was he produced?
Produced on the next date, on 3/5.
At what time?
Your Lordship, there is no specific mention, but in the FIR, there is page number, just a minute. Page number 12.
Your TCR is not there. TCR anywhere that noting when they were moved out of the police station. You have
to go through all that TCRs very minutely, very difficult.
Thing is, what we find is he was taken into custody 11:30 AM, prior to 11:30 AM. At any cost, because that is the time you reached back the police station along with everybody. So before 11:30 AM on 2nd of June, he was taken into custody. 2nd of May, he was taken into custody. Now, what time did they move from the police station is the only ground he may have.
Order will reflect.
Number one. Number two, Nalbari. Arrested at Majuli, informed at Nalbari. Tell us. At 2 or tomorrow?
At two also.
At 2.
Lordships, his arrest was around prior to 7 a.m. because the seizure was done at 7 a.m. Your Lordship. He was detained and there are Supreme Court judgments, Your Lordship.
I have told him it is at least prior to
At least prior to
11:30. So anything after 11:30 is not going to work. If it comes down to somewhere in morning half,
Lordship.
then we will go to whether it is 7 o'clock or not.
Yes.
At 2 o'clock?
Nalbari, but that 48 notice was given to my lord, the wife of that is Anil Vora, my lord. Justice has indicated.
No, 48, the 48 notice was sent to Nalbari, Majuli,
It was
from
sent in
Majuli.
WhatsApp, Your Lordship, first of all.
Huh?
It was sent by WhatsApp to
That will
the
not work.
mother of the
Vicky Burman.
Her name is Deepika Burman.
At page 27.
27.
What I found from the my lord, 48 notice,
And
my lord. It was
Yes, Your Lordship. Previously, it was served to the wife of Anil Bora. And then a few
was
days later,
Anil Bora cannot be for Vicky Burman.
wife of Anil Vora.
I
Anil
also-
Bora's wife, why should she be some friend, relative nominated by arrested person?
Because they are, my lord,
Once we say that that wife is respectable, we will not take into consideration the husband. Why
Okay.
should a co-accused give the nomination to the wife of
it
a
was served,
co-accused?
my lord,
and Your Lordship,
Served to whom?
Pandita Soika Bora, my lord. Her
48.
signature is there.
48.
48.
Doesn't work.
there are other procedural lapses as well, Your Lordships. And the IO has invoked section 4 and 5 of the Assam Bhang and Ganja Prohibition Act, which has been repealed in the year 2022, Your Lordship.
He has done his level best. Let us not discourage him.
When the charges will be framed, my lord. It is his, for his own benefit, that will go when charges will have.
At 2.
My lord. Only thing, my lord, regarding the appearance, my lord, when he was.
That part and
And
48 notice,
48 is clear, my lord, that he was served to Bondita, that is what.
that will not work.
That is Bondita.
How will that work? Anil Bora is not a petitioner here anywhere, is he?
No, my, Anil Bora, my lord,
He's
is
not.
one of the accused. my lord.
Maybe,
He is the accused from
Maybe.
whose house the thing was-
maybe, but when the name at the top is the mother's, how would serving it to someone else help?
Mothers.
It has to be to the nominated person, not even to the son of the nominated person. At 2, tell us. At 2 বজাত. Sleep মাৰি থাকে এইফালে ভাঙিছো.
Wait, please, Your Lordship. Lordships, the HRE was called for,
It's very not received, my lord.
and it is,
He is behind bars since
28/5, Lord.
28/5.
28/5, sir.
28/5, but today is 88 days almost.
6 months is the mandatory period. my lord.
Commercial control.
6 months is. 6 months. Right. And my lord, forwarding report, if your lordship may go. It was seized from his position,
She's from his what?
my lord.
This is a truck driver, Lordship, from the body of the truck. It was concealed in the
He was
body
the
of the truck.
driver, body of the truck.
You are driving the truck. It is concealed in the body.
Yes, Lord. There's some
Lordship.
story, Lordship.
Huh?
There's some story.
20
Other story was also there.
22,000.
Let the city count.
So my lord, multiple quantity, my lord, multiple.
Yes, multiple
Quality, my lord.
Quality is also different.
Different, my lord. 56, my lord. One
Now
heroin-
different qualities also coming up.
Heroin, my
Different
lord, my lord.
varieties also.
My lord, regarding the my substance, my lord. Heroin,
Something is
Yeah,
pure, something is little
Yes.
impure.
yes, that is heroin, then Yaba tablets, everything is found.
No sweetener is mixed with that. No sweetener is mixed with that.
White and
Only whitener, no sweetener. We'll have it on 3rd of September
no,
or 7th of September,
8, my lord.
8th of September. along with the CD. It has been noticed that the petitioner was arrested on
28/5.
28/5/2026. Stop. The APP shall bring the same to the notice of the IO and call for the CD.
Plus,
Yes. Yes.
Like in this case, Lordship, CD was called for commercial. Yes.
CD,
he might not receive minor. Again, on the same date, he was arrested.
28/5. 25/5.
24/5, man. He got a logo.
Like we have to ground that,
Huh?
we have to ground that 47 notice was served in English. Not in
47 notice was served to you in English.
in English, not in vernacular.
Now, why is this not told to the remand magistrate at the first time that, sir, I did not understand these papers which is being given to us? I don't know what is it is all French and German to me.
He had signed in Assamese.
Huh?
He is,
I sign in Assamese in most unofficial documents.
it is the duty of the police laws.
Huh?
It is
Ah,
the-
yes. Does he understand English? He's saying it is your duty to prove.
No. Please reply to the order, my lord. Otherwise, it is, she has signed, my lord.
Is it mandatory that it has to be given in English?
It is
No.
not mandatory, my lord. Only my-
Mandatory is in vernacular.
my
The
lord,
linguist
mandatory-
understand by the
my-
arrestee.
That not vernacular, my lord.
The
The
linguist.
language understand by the
Arrestee.
So you are saying that the signature, he may not be able to read and write, but he understands when English is spoken to him.
when my lord. Whether he's explained or not, that is also, my lord, not clear, my lord. Whether he-
When he is alleging 47 violation,
No, sir.
at least your 48 notice is correct.
48 notice is same.
It is
The
also in-
signature of legal guardian is in English,
Is in English.
Is in English.
so you cannot take that ground.
We are not on.
He did not understand and it was served within time.
My lord.
Within time.
Then what is wrong?
Only that ground that.
If 47 is served but 48 is not, there is a law saying that it will not work.
Regarding.
But if it is said that if 48 is correctly served,
But I am not saying only because he has signed in English. He may not understand the
we
content,
do not know.
No,
We'll
47.
presume.
but it is mandatory that 47 notices to be served. The linguist understand by the arrestee. In Mihir Ranjan, Rajesh Shah,
Heard learned advocates for both the sides is there. He understood everything.
oh, case 19, Lordship.
Page 18.
18 is the,
He engaged a counsel.
no, that,
48 notices, family engaged a counsel.
under 40, page 16 to 18, this is the order passed by the landed court below.
Yes, this is
Reject-
today the case diary has been submitted.
Case,
Oh, there is an earlier order.
well, that was rejected by the court.
Earlier order is remand order. Where is it? Show us from the remand order that he did not understand. We'll have it fixed on the 3rd
Not,
for the case diary. You also give us the remand order.
Lordship.
If he has been able to engage an advocate on that day, if the advocate was heard, 48 notice duly served, full opportunity of being
The-
heard. Only your statement that I signed in SMS and I do not understand English. It will go back to you to show that you do not understand English.
Not it is,
They have done their part.
it is the duty of the police
They have
On
shown
the-
us that there is a signature.
But- while the notice was served.
I gave them the notice. There is nothing on record before the remand magistrate to show that he did not understand English. 48 notice properly served, properly defended at the time of remand. Everything else goes.
I place that order, Lordship.
on ninth, my lord.
Signature on a different language would not mean or lead this court to understand that he did not understand the notice. More so in this case because 48 is completely served and whether he was properly defended at the remand. That is all we will see. That is the crux of 21 or 22B, either which ways. You should be defended at the time of remand.
Learned counsel, learned advocates for both sides.
Once you make an allegation that you do not understand English, is it not for you to prove that you do not understand it? It is something within your specific knowledge. How would they know?
But on the day, Lordship, when the notice was served.
That is what we are saying. They have shown that the notice, they have shown that the notice is served. This is your signature. You do not deny the signature. Whether you know a particular language or not, that you have to take it up somewhere when you are produced on remand, when you are fighting the bail. Telling it to us after 6 months. Why should we hold those records wrong?
My lord, it is the duty of the police.
They have shown it to us. That is, we think the duty is complete when they have shown us your signature on it, which you do not deny.
We can obtain that in.
I can learn to sign my name in Tamil without knowing a word of Tamil. Yes, then I'll give the signature and say, no, I don't know English, I don't know SMS.
Well, it is the specific plea of the petitioner.
Where?
Arrested that
Where?
he has.
Where is that plea? Here.
In the bill.
Here. Was it there before the remand magistrate?
That is.
Sir, I don't understand. I don't know why I'm arrested. I have signed it. I don't know why I'm arrested. My family may know. I don't know, sir. Where is that stand? Absence of a notice and whether the requirements have been fulfilled are two different stages, sir.
Anyway, the remand order, Lordship.
Whatever you need to bring, you bring on record by 3rd. List again on the 3rd, allowing the learned APP to call for the CD and also allowing the learned counsel for the petitioner to file an additional affidavit, bringing on record documents that he would like to bring on record.
Yeah.
Yes, sir.
The petitioner was arrested on 27/7/2026. Suspecting that we are transporting some cattle to outside of the state. Absolutely false allegations. The loss of kindly see affair.
You are for?
Yet to receive my page 9.
You are for all the 3?
Yeah, all the 3. So all the cow are now their custody. And we are now 29 days they were in jail. Actually, we are not transporting the cows to other Meghalaya, but we are transporting to cow to my native place from the government. When they passes the.
What is your native place?
My place, the petitioner one is there.
On the same vehicle?
My lord, yes.
In the same vehicle?
Yes, same vehicle, my lord. Same vehicle.
In the same vehicle, you are bringing from Boku.
Yes.
To
Borpeta. Borpeta, my lord.
Via Gorchuk.
Via
Boku to Borpeta.
Via
Gorchuk.
Via Hazu.
No, this is Gorchuk.
It is near Goramari. It is near Goramari.
Oh, this is another Gorchuk.
Yes, my lord.
My bad.
So we are to my native village for purpose of cultivation.
Yes, sir.
So on the 29 days we are in my lord.
CD were not received, my lord, but it was seen that in a small vehicle, around 16 numbers of cattle were loaded and they were apprehended.
And we purchased it from the market, my lord. 29 days we are in the now custody.
Now this, yes, further custodial interrogation necessary.
So my lord, regarding legal transportation of cattle, what is stated, my lord, is from Borpeta to the state of Meghalaya, my lord. Interstate transfer.
No, the vehicle, he is saying it is from Boku to Goroimari.
When we reached the Goramari, then they intercepted it.
Huh?
Then they intercepted.
Where did you live?
It was is the affair, my lord. Page 9, my lord. Stolen vehicle,
Page
stolen
15.
cattle from Bagbor, Barbara district to outside the state of Meghalaya through jurisdiction area of Goramari police station. Actually, we purchased the cow in a market, my lord. Market naam to give. We purchased it from Jahirpur market. Then when I just moved, then police got an information that we are transporting some cattle. Then when we reached
Can you have it by the second, sir?
Second,
Huh?
second.
Confirm from from where they were going to where?
As per the revealed, my lord, that they are coming from Borpeta towards, through Goramari, they will be going to Meghalaya, my lord.
Just in.
paragraph 8, my lord, I mentioned. Investigation is complete, my lord. Nothing is
Just
left over.
Sorry, pass.
Zohirpur কোন জায়গা? আমরা Zohirpur কোন জায়গা?
No. So. How many cattle were there?
16, my.
16, man.
You have accounted for 12 in your receipts.
No, 12, my lord. No.
In your receipt, you have accounted for 12.
Now one, some received 2, some received 3.
Ah, I've counted that. Azure, Eta, Dahing, Ronga, Kola, Boga, I have counted everything.
1 or 2 may be missing, my lord. 1 or 2 may be
So
missing.
those 4 need to be investigated. We'll have it on 2nd. This taken on the 2nd of September, allowing the learned APP to call for the case diary. Learned counsel for the petitioner has submitted that the petitioners have completed more than a month.
29 days.
29 days in custody. Yes, next you.
My lord, the 16th is here. 16th. In our receipt, it is from 16, my lord.
Anyway, we have not recorded it is 12 or 16. We will count it on this thing. Let the CD come on 3rd, we'll do it.
Item 34, my lord, charge sheet
With all
letter.
respect, lordship,
Ah,
Charge sheet letter.
as per this petition is in jail, lordship. Today is 50 days, lordship. Now, lordship, the FIR register under section 20 small b NDPS Act, lordship. That is intermediate quantity. The contraband is heroin, lordship. And now, lordship, page 17 annex 3. This section 47 notice, lordship. This notice, lordship, it is section 47 and of the BNSS. It is clearly mentioned. It is the particular all it is Z. But as per this notice, lordship, there is no mention place of occurrence, lordship. The particular arrest of person, name of the accused persons, address and name. The next, lordship, ground of arrest, it is clearly mentioned. PS, name of the police thana, name, reason of the arrest.
Hmm.
There's no mention lordship. Place
Name of the,
occurrence.
name of?
Place of occurrence, it is not mention lordship. This section 47 notice lordship. And now lordship, I mean 15 days in custody lordship. We full cooperated, already
Yes.
submitted lordship.
Yes, sheet submitted, my lord, on 37/6, sir.
We call for the TCR here.
No, sir.
You're doing, no? The learned APP has submitted that the investigation is culminated in CS number.
59/26 dated 37/6.
Full stop. The learned counsel for the petitioner has submitted that the notice under section 47 of the BNSS does not indicate the place of alleged occurrence of the crime. Full stop. Call for the scan copy of the TCR list again
With
on
all respect, lordship,
8th
maybe
of September.
28 lordship.
Huh?
28.
Not this week. Next week we have got
On Monday, lordship. 30. 30. 30.
the bond.
If possible, lordship, 30.
31st of August. Okay.
31st. Deeply obvious, lordship. May I please, lordship?
Hmm.
And you said the last order, my lord.
Ah, yes.
Yes, I have gone to the record, my lord. Here, my lord, although information found at 9, my lord, 9 AM, my lord.
Hmm.
Hereafter, my lord, police party proceed towards the, my lord, Bamuni village at 10 AM, my lord.
10 AM.
10 AM, my lord.
Okay.
My lord. Thereafter, my lord, seizure, proceeding formalities. 12 noon is for the place to my lord. Thereafter, seizure was made, my lord. Then seizure was at 11:54.
No time of seizure.
Huh?
Number 16.
Hmm.
Seizure was made at 11:52 AM.
11:50.
52 AM
Ah.
in the morning. Thereafter, my lord, they proceed to the, my lord, police station, my lord. And thereafter, my lord, GD entry was made 47 for thereafter, my lord, and formally, my lord, arrested on at 7 PM, my lord.
Let us not go to. And
Three
when was he
and six.
produced? When was he sent?
My lord.
Formal arrest we don't require, sir. Once you have taken him into custody, it will be sometime that only when his arrest starts. When was he produced?
My Indian next day, my lord. Indian next day, produced.
Next day when? Second half.
My lord, partner, it is not mentioned, my lord.
Ah, there will be a GD entry of his movement.
My lord.
There will be a GD movement of
My
his
lord, GD entry.
a GD entry of his movement. Will there not be?
Therefore,
Ah, 2:15. At 2:15.
okay.
Now, if you have moved him out of the police station at prior to that time,
My lord.
prior to your seizure, at least. Other part of it is in traffic, okay. Any GD entry showing when he was moved out. Heard learned counsel appearing for the petitioner, also heard Mr. Sharma learned APP TCR call for has been received. The learned counsel for the petitioner has submitted that it would be apparent from the records that the petitioner had been arrested and petitioner had been eligible. It would be apparent from the records that the police authorities had moved to the place of occurrence at 10:10 a.m. in the morning, and that the seizure had been completed by 11:52 a.m. in the morning, full stop. The police party had reached back along with the seized article and apprehended persons at 12:10 p.m. on 21/6/2026 at the police station, full stop. The learned counsel has submitted that thereafter the petitioner had been produced before the learned remand magistrate at 2:15 p.m. on the next date, that is on the 22nd of June 2026. Full stop. He submitted therefore the window period of 24 hours for production of the accused before the learned remand magistrate after the arrest had elapsed, and therefore the further detention after 24 hours of his arrest has been rendered illegal, and the petitioner would be entitled to the privilege of bail. Full stop. The learned APP has submitted that the petitioner was formally arrested on 21/6/2026 at 7 p.m. and therefore the production of the petitioner before the learned remand magistrate at any point of time prior to 7 p.m. on 21/6/2026 or 22/6/2026 would suffice the requirements of law. It has been settled by the Honorable Apex Court in so-and-so versus so-and-so, reported in so-and-so, that the custody of an arrested person is initiated the moment he is restrained by the arresting authority from using his liberty of movement. Full stop. In the aforesaid view, this court has to understand that the petitioner had been taken into custody at least at the time of the seizure of the goods, and thereafter it is only the formal arrest which has been shown to be at 7 p.m. on 21/6/2026. Full stop. Anything?
My lord. Not found, my lord.
Moved
Other
at
details-
11:50, sir, we are with you. If he has gone out of the police station at 11:50, I am with you.
My lord,
I will reject the bill
my lord.
on that ground. 11:53, I am with the petition.
21/3.
The learned APP has not been able to trace from records that the petitioner had been sent for production before the remand magistrate prior to 24 hours being completed from at least 11:52 a.m. on 21/6/2026. Full stop. In that view of the matter, since the petitioner had been produced before the learned remand magistrate on 12:15 p.m. on 22/6/2026, I am of the considered opinion that the detention of the petitioner after 11:52 a.m. on 22/6/2026 has been rendered illegal. Full stop. However, since the petitioner and since the accusations are under the NDPS Act, I deem it fit to release the petitioner on bail upon stringent conditions to ensure his further participation in the charge-sheeted in the trial, and to dissuade him from hampering or tempering the trial process in any manner whatsoever. In the aforesaid circumstances, the petitioner shall be released on bail on furnishing a bond of ₹50,000 with two sureties of the like amount, one of whom shall be a government servant, to the satisfaction of the learned trial court. Full stop. The learned trial court shall be at liberty to impose such other conditions on the petitioner to ensure the further participation in the trial. full stop bail petition accordingly disposed of.
Special NDPS case 57/26 may be mentioned.
তো আপনি সেই ওপৰত লিখিব নহয় ডিচিশন petition under section so and so open থাকিব petitioner নামটো থাকিব তাত হ'ব আচ্ছা ইয়াতে স্পেচিয়েল NDPS কেছ নম্বৰ দিয়া নাই ইণ্ডিয়া ইয়াতে মই লিখি দিছো NDPS কেছ নম্বৰ
57 of
57 of
26.
2026 pending in the court of
Special Judge Porpeta.
special judge বৰপেটা হা ইয়াতে অকল সেইটো লিখি থৈছে এই PS কেছ নম্বৰটো আছে আপুনি which culminated in NDPS PS case. Yes.
All right.
Yes, sir.
Also kindly peruse the last order of this honorable court lordship. I am behind the bar for 56 days. In fact, lordship, mandatory period is 60 days, except section 316, subsection 5, which is not attractive in the present case. On the last
What is the this thing?
Allegation is at page lordship 10.
Page 10.
Who that? 54. 54. Well, that's charge sheet submitted, man. Charge sheet submitted.
When?
Charge sheet 19/8, madam.
This matter was last listed on 19/8.
Madam.
Yes, tell us further custodial interrogation necessary. Allegation is one letterhead of the BTC had been used with a
Right.
false signature.
My lord,
Custodial interrogation.
after investigation put is submitted charge sheet, madam. Here are two options, madam. Lordship letting APR court below. Otherwise, lordship may call for trial court record, madam. To find out his involvement in other matters.
We are just asking whether whether her custody during the trial is required if
Investigation already completed.
completed.
My lord, investigation completed.
The forged document is with you.
My lord.
Why should she remain in custody in the meantime?
My lord, at present, my lord, lordship may kindly peruse the trial court record, my lord, and thereafter lordship may consider, my lord.
Already 56 days.
Whatever they may be, my lord, but investigation is completed at this stage.
But all sections, the punishment is extended to 7 years, except 316 subsection 5, which is not attracted in the
Lord,
present
kindly
case.
peruse page.
Which is
11,
not
my lord.
attracted by?
In the present case, your lordship, petitioner is not
My lord,
the
page 11, my lord. For a moment.
Just a minute, huh?
Page 11.
petitioner
come.
is not the government servant or bankers or.
Yes, you showed us that, yes.
Your lordship,
Yes, yes.
Page 11, my lord.
Hmm.
The ground of arrest, my lord. 9, my lord. Here, my lord, accused person is involved in several cases, my lord. Lordship may kindly peruse. Page 11, my lord.
Oh,
Para 9, my lord.
My lord,
Same
repeatedly.
offense, my lord. Same type of offenses.
my lord, this is, he has not yet been convicted.
May not be.
This is
May
why-
not be. Should we wait for convictions when there are? Should we spell out? To all sorts of added sections, Assam Police Act, everything. That is what we were wondering last time, why Assam Police Act
Assam Police
against you? Don't know. Again, impersonation and all. Would you like to approach there or should we call for the TCR? Scan copy.
Your lordship is not granted bail, then I may be allowed to approach before the trial court because Sashit has already been. In fact, lordship 56 days. The present case is lordship.
No, but since all the record will be before the trial court,
Hello.
they would better evaluate whether your further custodial interrogation, further custody during the trial would be necessary. The nature of the offenses that are alleged against you in the charge sheet,
Yes.
whether you're keeping you in custody would be more beneficial. That is what they would have to see.
My lord, your
Once
lordship,
they see and reject, then we can look into it.
that
It
is-
will speed up your process there. Maybe your
your
custody would
lordship is
not.
not pleased, then
The learned APP has submitted that the investigation had culminated in charge sheet number.
112 of 26, dated 19/8/26.
First of learned counsel appearing for the petitioner has submitted that the petitioner would appear before the would approach the learned trial court.
that may not be recorded, lordship.
Huh?
That may not be recorded.
Full stop. In that view of the matter, the learned counsel for the petitioner prays for closure of this bail petition with liberty to approach appropriate forum. No.
I am not praying for that.
Then
Lordship.
what would I say?
Your Lordship may remand the matter,
Okay.
giving liberty.
Charge sheet, full stop. Since the charge sheet has been submitted, this court is of the view that the petitioner should approach the learned trial court before trial court, which would be equipped with the records to consider the release of the petitioner on bail during the trial period. Full stop. With such liberty, this bail application is closed.
Nice, please, Your Lordship. Here, my lord, petitioner was arrested on my lord 3/7/2026, my lord, and as on date, my lord, 53 days in custody, my lord. And
Wildlife. Huh?
50
Huh?
Special BP is there, man. Special BP is there.
Wildlife is there, my lord.
Special PP. Because this is not an offense against human beings. You are committing offenses against animals. So let the special PP be here at 2 o'clock. Inform him.
May I please, Lordship?
Hmm.
POCSO case, my lord. The victim has been examined, informant also examined, my lord.
Yes.
Victim is page number 26, my lord.
Well, service report awaited, matter.
But as per the statement of the victim, my lord, POCSO has not been attractive in this case.
Huh?
As per the statement of the victim, the POCSO has not been attractive, my lord. In page number 26 is the
Service report
statement.
Huh? Service report is fine, but what about the statement of the
26.
victim? Have you seen?
My lord, I have not seen, my lord, perhaps if my lord, it is
26. Short statement.
But as the case is, my lord, it is registered under POCSO, my lord. Perhaps it is required, my lord.
See page 26 for
Right.
once. We'll appoint a amicus, no
Right.
problem, but
My lord.
look at the see the statement number 3. PW1, third paragraph.
He's 17 years old, the victim.
Look at the cross. Huh?
Trial could reject it after prayer, my lord, after recording this statement.
Something happened inside a tin shed.
My lord. PW2 is the, my lord.
No, something happened inside a tin shed. That must we agree to.
My lord, my
It
lord.
happened inside the tin shed. No one outside the tin shed would know, other than the 2 persons inside.
Something is there, my lord.
Yes. The victim says, we were standing in the roadside talking. Where does the tin shed come in from? Heard learned counsel appearing for the petitioner, also heard the learned APP, who submits that the service report on the respondent number 2 is awaited. Full stop. The trial court records has been received. Full stop. This court had already recorded that the statement of had already recorded the submission of the learned counsel for the petitioner that the statement of the victim itself does not attract any of the provisions of the POCSO Act. Full stop. In such circumstances, this court deems it fit to appoint Ms. M.K. Brown, learned learned counsel as the amicus to assist the court and defend the interests of the informant and or the victim. Full stop. The learned counsel for the petitioner shall furnish a copy of the bail petition on the learned amicus during the course of the day. Full stop. List the matter again on 27th of August 2026 for further consideration. কেইটামান থাকিব এডমিশন কেইটা হল বেইল হিয়াৰিং আছে আৰু বেইল হিয়াৰিং আৰু অৰ্ডাৰ্ছ আছে ন উইল হেভ ইট এট 2
Submission, my lord, I am citing a decision of the Honorable Supreme Court, my lord, reported in 2003 8 SCC, page 77, my lord. Paragraph 7 is the relevant part of your judgment, my lord, whereby it has been held that there is no any bar in granting pre-arrest bail, my lord. When the main accused of petitioner, the accused number 1, the son of the petitioner has already been granted this default bail, my lord. Consider
Yes, would you require his,
CD, my lord.
no, once the charge sheet has been submitted,
My lord.
he would not be arrested by the investigating authority any further.
No. He will appear, so he will definitely, he will appear, he will assist this, that inspector said. Inspector, as and when required, my lord.
No, he has to appear before the trial court as and when he receives.
I'm ready, my lord.
So, I would record that now the investigating authority has no business to arrest him since the charge sheet has been submitted.
My lord.
And further on receipt of summons,
My lord.
the mother, the husband,
Oh.
and you would appear before the trial court
My lord.
as and when necessary.
My
Before receipt of summons, there is no question of any arrest.
My lord. My lord.
Heard Mr. N.C. Das, Leonard, Senior Counsel, appearing
J. Bush, Your Lordship.
Appearing with the assistance of Miss J. Bush for the petitioner. Mr. MP Goswami, learned APP appears for the state full stop. This is a bail petition in connection with, this is a bail application filed under section 482 of the BNSS for grant of pre-arrest bail in connection with Ramakrishna Nagar PS case number so-and-so, registered under so-and-so. The petitioner is the father-in-law of the deceased.
No, petitioner is not father-in-law, my lord. Petitioner is the father of this, principal accused number 1, my lord.
The daughter-in-law had expired.
Well,
So father-in-law of the accused of the deceased.
deceased.
That is what I had said. The petitioner is the father-in-law of the deceased. And the learned senior counsel submits that the husband and the mother-in-law of the deceased have been granted bail by the courts below.
No, mother-in-law is not a party, my lord.
Who were granted bail?
Yes, son, my lord.
The husband. Okay.
Husband.
Okay, you keep it like this. And learned senior counsel has submitted that the husband of the petitioner had been granted bail by the judicial magistrate first class on 13/7/2026. Since the case diary had not been, since the charge sheet has not been submitted within 90 days of detention in judicial custody.
Not the husband of the petitioner, the son of the petitioner, my lord.
Husband of the deceased, my lord.
Husband of the deceased.
Husband of the deceased had been granted bail. Full stop. The learned APP has submitted that the charge sheet has been submitted by CS number.
29/26 dated 27/7/26.
Full stop. On consideration of the materials placed before this court, there does not seem to be any apprehension or requirement of the investigating authority to arrest the petitioner herein, since the charge sheet has already been submitted. Full stop. Accordingly, this petition is closed, requiring the providing that the petitioner would appear before the learned trial court if and when summons are received. In the event the petitioner is put up for trial, anticipated bail application is accordingly closed.
Published to lodge.
Maybe I've checked the records, my lord. He was in jail for 2 days, otherwise, and he was released on bail on the ground that the sections attributed were bailable then. Since the sections were bailable, he was granted bail.
No, whatever, he has spent
And
2
otherwise,
days.
for 2 days, only applicant number 1, my lord, Panna Lal, he was in jail for 2 days, and rest of the accused, when they received the summons, they appear before the court and they got appearance bail after appearing before the learned court.
So what do we do with 325 for the others? Where is that order? All convicted under 325.
All convicted, my lord.
325 and 323.
323, 2 years.
One.
My lord, may I submit one thing?
Bolo.
My lord, this case, my lord, here.
এখন diokson.
Otherwise, my lord, 325 at that relevant point of time. Compoundable.
With the permission of the court.
Where is the judgment? Who struck the blow?
Lordship, Panna Lal.
And the others are under 34.
34, 149 was also there. That was.
Huh?
149 was
Earlier, 149 was also there.
No, that was.
That was.
We don't want that. Unlawful assembly is set aside, na?
set aside, my lord. The 323 and 325 remains. Yeah, pray one thing, my lord,
Anywhere here
Like-
which shows that who had struck the blow?
my lord, Pannalal, my lord. Your lordship, I am not. The witness was there before. in fact.
Where is that?
Lordship, yes.
What is this judgment?
But otherwise, some of the witnesses, they say PW3 says Rupak Devnath has assaulted Rahul from backside.
Don't show us something by which we have to uphold that 325 in favor of the others. Show us something
Well, my
that
lord, I'm,
325 will be not applicable to the others. Then we'll go for the fine part. What is this judgment you have given?
Lordship, judgment passed by this learned CJM, my lord. Oh, my lord, I am citation, my lord, this is passed by the apex court, my lord. Here the cases.
This is what you have given. This is what the Supreme Court can do.
My lord.
As well as High Court to
Huh?
Direction, observations is there, my lord.
What?
By invoking 482, my lord, even High Court can do this. My lord, pay para. If a lordship takes down para 13 and 14 as well as para 20, my lord. Basically from 19, my lord, if lordship goes, my lord, para 19.
Take down. Heard Mr. Swen counsel appearing for the petitioner. Also heard the learned counsel appearing for the respondent.
Which of the,
No, respondent number.
two lordship.
Respondent number
Informant, this
2.
is Reba Dasgupta, informant in this case.
Yes, Mr. Goswami. They have shaken hands. 2012 incident. No,
12.
2012
my lord.
incident. 2 years. And some fine. So we'll find that there's nothing in the judgment. I could not trace out that all of them had dealt separate blows under 325. So that part under 325, for the rest we'll say not considered properly. And for the other one, the number 1, and if he has undergone 2 days of imprisonment, so we'll restrict it to that. Close the issue.
Sustaining that only.
For number 1. He was then aged 40 years. Now he will not go for a government job, hopefully. Huh? Now he will not go for a government job. Yes, heard Mr. Swanson. Also heard Mr. MP Goswami, Learned Counsel appearing for the as the APP. Full stop. The present. You do one thing. You take it as allowed. I have given what we have done. We pass the order in the chamber. We are in a bit of a hurry. Huh? We'll sustain it for 1. For 1, saying that period undergone 2 days and the fine imposed. Whether you pay or don't pay, I don't know.
Otherwise,
And for the rest, we'll,
otherwise, my lord, this judgment, my lord, it was a 326 original. Case was of 326.
We'll see what we can do.
I'll leave it alone.
But we'll close it.
I'll leave it alone.
We are not
Highly
going back
obliged,
to jail. That is
highly
what we
obliged.
can say.
Deeply obliged.
We are not sending anybody to jail on this.
My lord. Highly obliged.
Case list number 29.
দুটা আছিল নহয় এইটো ডিসপোজড আজি দি দিম এইটো
I'm for 29.
tell us
I am for item 29.
29 to do 29 to give. Yes.
In 29, my lord, the seizure was made on 7 a.m.
Uh-huh.
If I have seen that.
Caesar 7 a.m. And
Next day time is not given in the forwarding, my lord.
but not before 7 a.m.
Not
hopefully.
be before.
So he gets the benefit.
He gets the benefit in that regard.
Hmm.
And regarding 48 notice, my lord, what I have found from the orders that this Vicky Bowman's father expired. And
Who?
this, my lord, petitioner's father expired, my lord.
Babcon, huh?
He is no more, my lord.
Your
Or-
lordship, we expect.
No, let us
He is
first.
long,
No, let us first go by item 29.
29.
Item 29.
29 I am submitting.
Huh.
He is so, my lord, one of his, my lord, father, he was expired, so it cannot be given to him.
Hmm.
And his mother, my lord, whom they have sent it through WhatsApp, my lord, she also resides in New Delhi, my lord.
Hmm.
So it was sent through WhatsApp also. And since he was arrested in the house of my lord, Anil Bora, my lord, so it was given, physically it was given to wife of
But WhatsApp will not do.
WhatsApp, provided it is, my lord,
And- Huh?
it was, my lord,
And after you have,
and they have also he also could not, my lord, say, my lord, where actually she resides, my lord. Address also not given properly, my lord. So that is one part, my lord. So
we will record that under in the section 48 notice you have submitted that she was not available at the address and therefore best efforts were made to have it served upon her through the WhatsApp messages. But looking at the infraction of the time frame, he would be entitled to bail.
Yes, my lord. There also I have one submission, my lord. At that time of remand, my lord, he had not taken this plea, my lord,
Okay, need not.
because
It was for the magistrate to see
magistrate to
whether the detention after 7 a.m. had been vitiated.
yes. But my lord, he should at least, my lord, in my humble submission, my lord, there also some decision has come out, my lord.
Saying that if he does not take the ground there, then he would be entitled to. Can you give it to us by when?
By tomorrow, I can give my, and for coordinate bench also, there is one, my lord. Though some facts were defined, my lord. There, my lord, honorable court has held that since he last time, my lord, it was this person married, he has not taken that ground.
But here it is not. Here it is not that case.
Here also, my lord, regarding bail, my lord.
No, no, here it is not his second round.
No, man. It was on that date, my lord, he was just paid for bail, my lord.
He prayed for bail, but this fact was overlooked by the remand magistrate, is it not?
But he has not, on that day, man, he has not taken this plea, man. It was not decided.
See, in fact, when the law says that the moment you take him into custody is the time the arrest starts.
Yes, that
Yes.
part is.
Now, if that happens, he may place it before the remand magistrate or not. It is for the remand magistrate to see what time he was taken into custody and after what time did it become unlawful. Had the bail been granted there on that ground that yes, this man was arrested so and so, his detention is after that time is illegal. He could have been arrested again and placed before the remand magistrate immediately with a 48 and a 47 notice or whatever. This is the situation, now take him in. He would have been taken in. Once there is a fault in the once is a fault in the arrest and the continued detention, what stops you from taking him in again? Grant of a bail doesn't mean that.
Yes, that is one part.
Therefore, it comes to this. When it comes to the bail, thereafter you cannot take him in. Once we grant the bail.
Yes, then
But once simply there's a declaration and he's allowed to move one step and he's back in again.
It was not, my lord, pointed out at that time, my lord. That is what, my lord. And since it was not, and after, my lord, now the arrest is after 4-5 months, my lord. 4 months, my lord.
Your lordship, he was not even provided a chance to put an advocate for him who can take the plea because.
Where is that? Where is that order here before
No,
us?
that is not.
You say no advocate appeared for him.
But
No,
it is stated
advocate was engaged for him before the.
Are you sure of it? Should we go
Yes,
through
your
the
lordship.
records?
I have got the
Then
instructions.
No.
he did not have an
Because
advocate.
nobody was
From the order.
available with him, your lordship.
He was one person has been engaged
as a, my lord, is
Counsel for you.
No, your lordship, it was for the legal
Because
aid
like I
defense
said,
council and
order
they have also
dated-
not pointed the matter, your lordship.
or ordered at 3-5, I flag mark, my lord.
No, if you say there is a direct judgment with differing with what we are thinking, then I will keep it for tomorrow.
Tomorrow, my lord.
Otherwise, it will be very unfair on my part to keep it for tomorrow when I am convinced
Yes.
that so 24 hours gone,
Yes.
he is required to be released.
Yes.
Your lordship,
One
the
thing
coordinate
I have,
benches
I
of this
will
court,
produce if
Hmm?
any-
the coordinate benches of the Honorable High Court has given entitlement of
I
the
have
bail.
given that bill, but he is saying that there is a certain judgment which,
I just want to go through this Supreme Court judgment.
because we may be required either to defer or
In
to
the first
concur.
half also, your lordship, similar facts,
Hmm.
more than 24 hours bail was granted.
Place,
That
my
time,
lord, one
Learned Council
your
did
lordship
not place any
coordinate
judgment.
One judgment is here, my lord, but I will just want to search any Supreme Court, my lord, because this is what your lordships have found from the lordships coordinate bench, my lord.
That will again vitiate all the judgments, your lordship.
Because in the test judgment, I
What
want
is the
to-
quantity recovered
It is commercial quantity.
commercial quantity.
from you
No, no, your
or
lordship.
from the house?
From the house, your lordship, the charge sheet, page number 46, your lordship. Sorry, your lordship, page number 36. Column number 1, suspected ganja, black colored vehicle, so and so, cash of rupees 3 lakhs, all seized from Anil Bora. From the house, everything. And from me, your lordship, page number 37, I am Vicky Burman, only my mobile phone was seized. The foundational facts does not establish that these items were, the contraband items were seized from me, your lordship, as per the charge.
Which is, where is your, this thing? From the position of Vicky, one blue color Vivo.
And your lordship, mere presence,
Yes.
it is a settled law, your lordship, mere presence.
Okay, be prepared with the judgment on the next date.
Yes, my lord.
No, for the next case. There is no recovery from him.
And most humbly,
No
pray, your
recovery,
lordship.
my lord, there are materials to show that, my lord, he is the person who brought those narcotic substances to the house of Anil Bora.
Where?
From the, my lord, TCR, my lord. Record, my lord.
Your lordship, the charge sheet
So
also clearly
merit-wise,
states that
my
was
lord,
not done.
that is the what I found, my lord. Because it was, they all were there in that house, my lord.
Show me the judgment tomorrow.
Okay.
Show me the judgment tomorrow if you have one day more.
May it be fixed on 26. Tomorrow I shall.
26th, okay, at the request of Mr. MP Goswami, Learned Council, Learned APP, list the matter again on 26th of August. Full stop. Mr. Goswami has submitted that despite the fact that the petitioner had been arrested at 7 a.m. on the morning of the date of the previous day, his production.
But my lord,
After
yes,
say 7
this
a.m. on
was
the,
shown on, my lord,
doesn't matter, sir.
yeah, that is what I'm.
On 7 a.m. on
Caesar
the
Avenue.
next date, it would not vitiate the further detention of the petitioner, full stop. We'll just go by
Lord,
day after tomorrow. Huh? Both 24.
I am review of this.
May it please, Your Lordship. My lord, since the cases, my lord, police case, my lord, so my lord, learned PP can appear in this case, my lord.
Not
So, my lord,
understanding.
Kottagam police station case, my lord. Schedule was called for, my lord.
It's a police case. What is the recovery from you?
My lord, my lord, 2 elephant tax was.
Time, my lord, not that, but because we are supposed to come. Just now it was.
After some time.
My lord, we are supposed to come. My lord, we are, so my lord, it's not.
After some time, let us see. 2 elephant tusks from the shop of the petitioner. From the shop of the petitioner.
Yes, sir.
Well,
Yeah.
May I please allow?
Hmm.
My lord, GST case, my lord, the petitioner was the lady, and as on date, my lord, 34 days. Basically, all documentary evidence, my lord, all they have been taken out. All they have taken, my lord. Yes.
Yes, sir.
Lordship, here is the case report with regard to the both item. Lordship, here her requirement further custody is required because the transaction is yet for verification of those transactions, how it was done. It's yet to be completed. That's the reason, because it involves a huge amount.
Huh?
All are
It involves
documented.
huge amount, Lordship. About
When was she arrested?
I was arrested on 27 2026 while I was in treatment at Siliguri, my lord. From there, they brought me.
From that day, you have not been able to complete the transactions.
No, because from her interrogation, new development has taken place for which in the next item.
We
question,
required, is there any protection in the AB?
AB was interim protection, but now, Lordship, I have come across a Supreme Court decision. Lordship, in GST, before arresting a person, there has to be a reason to believe by the Commissioner of GST. And thereafter, he has to serve an order under Section 69. And only after that, the right for approaching for pre-arrest bail gets started. And here in the second case, Lordship, only notice under 35 BNS was issued. And here he has pleaded the facts of another case. Not, he was asked to appear in connection with Krishna Burman case. And Lordship, on that basis of that notice.
Therefore, before arresting this lady, the commissioner had to give her a notice on this also.
Here everything against Krishna Burman, Lordship, everything was done. Grounds of arrest, everything was given.
No. You said that the commissioner is required to give a notice.
Lordship, in the AB, I am saying. Because
Whether there is an AB or there is no AB, we just forget that.
That was
I'm just trying to understand the procedure. Commissioner has to give you a notice.
First of all, Lordship,
That moment you can, before arrest, you can run and go for a pre-arrest bail. In her case, was it given?
Lordship, first of all, she was given notice under 35 BNS. She didn't fully cooperate. Thereafter, she was not available. And thereafter, there was a order for arrest, and that was given to her father. Then she was arrested from Siliguri.
So she's unmarried. Okay.
And because as per the apex code, either it has to be given by hand or through their electronic media. Because at the time of registration of that form, they are required to give their email address and everything.
That was given.
Yes, Lordship.
For the lady, it was given.
For the lady, and by hand also, it was given to her father. And in the second case, Lordship, that situation has not arrived.
I am appearing in second.
How do we come to that? No, but the first case.
First
Now,
case-
after 1 year of custody.
No.
34 days.
1 month.
34 days as on today.
Oh, I thought it was 25. Sorry.
That is also apex court decision, man, in respect of GST cases. All documentary evidence, my lord.
That is their Lordship. That I can.
All documentary they have taken, they have seized. What remains, my lord? I be in a jail, being a lady, my lord, unmarried, like 27 years of old, my lord. And lordship will see page 17, my lord. They themselves, they said, my lord. If your lordship allow me, I'll just read one paragraph 5, my lord, of page 17. That is the part of the complaint, my lord, that as per the restriction of the record so and so, the firm is engaged in the business of wood and articles and so on, listening so and so, falling under number so and so, which are taxable at the rate of.
Which page are you reading?
17, my lord, is the page of the complaint.
Huh.
They could not have any recovered anything from me, contrary to the.
Page 17 is not the sentences you are reading.
My lord, para 5, my lord. Next, lordship will see that the
which are taxable. What mark করলাম? Wait. Then para 12, my lord, sorry.
Also, just after paragraph 5, 6, the details were given.
No,
what
para
section.
12, lordship,
That
kindly
was
have
an
a look.
Initial preliminary details, Lord.
During the course of inspection, so and so, the business premises of Tisha Burman GST number, the investigation team did not find stock of goods or other places of the business which could not
Oh,
be.
that is what is going against you, sir. They are saying that you don't have goods and you are making bills.
Yes, my lord, I am just a mediator, my lord.
Ah, so you were,
I
you
am
did not,
mediator, and they have seized everything, my lord.
you did not have any goods.
Yes.
You were passing on bills from this side to that side, and in
Yes,
the
yes,
meantime, you
getting
were
it,
gulping
yeah.
down the GST.
Okay, in 5, it is clearly stated that she deals with goods and everything. There has to be a storage for all those things. Lordship, it's not that small.
But then otherwise, Vinit Jain tells a different story.
Lordship.
Maximum sentence is 5 years with fine.
That's your Lordship, only the custodial part.
And I am in judicial custody.
Further, it is required. Other case we'll see, AB will see what to do, but here I don't think the further custodial interrogation. Heard. Mr. Borvian, learned counsel appearing for the petitioner, also heard Mr. B. Chaudhary, learned counsel appearing, learned standing counsel, GST.
Yes.
Full stop.
For
The
resolution
petition.
number 2.
The present is an application under section 483 of the BNSS read with so and so for granting bail to the accused person who was arrested on 27/2026 in connection with case number so and so. Both you'll find in page 1, huh? Stop. The learned counsel for the petitioner has submitted that the evidence required for the investigation, etc., are all documentary and electronic in nature, and the petitioner has languished behind bars for more than
34 days.
33 days. Full stop. The learned counsel has submitted that releasing the petitioner at this stage by imposing appropriate conditions would not in any manner hamper or tamper with the investigation, and in fact the petitioner undertakes to participate fully in the investigation process and cooperate with the same as and when required to do so. Full stop. The learned counsel has placed reliance on the order dated 28th of April 2025 passed by the Apex Court in Criminal Appeal number 2269 of 2025 in Vinit Jain versus Union of India, where the Apex Court has observed that the appellant was in custody for almost 7 months and a charge sheet was submitted in there. Here there is no charge sheet.
My lord, the complaint case basically.
Is triable by a court of judicial magistrate, and the sentence is limited to a maximum of 5 years, and the prosecution being based on documentary evidence with there being no antecedents, the accused would be entitled to a bail unless there are some extraordinary circumstances involved. Full stop. The learned standing counsel, GST, has submitted that from the statements made by from the interrogation of the accused, petitioner herein, the further investigation is being carried out, and therefore the petitioner may not be released on bail at this juncture of the investigation. Full stop. I have considered the relevant submissions and also the materials placed before this court, and I am of the considered opinion that the petitioner, a young lady of 27 years, in the present case would be entitled to the privilege of bail in the event the conditions are imposed for her participation in the investigation process. Full stop. Accordingly, the petitioner shall be released on bail on furnishing a bond of rupees. How much GST did you?
My lord, this
Very small amount.
Retired person.
9 crores.
It is relating to other
3 lakh 89
Of furnishing a bond of rupees 1 lakh with
Like
2 sureties of the like amount to the satisfaction of the satisfaction of
CGM Kamrup.
CGM Kamrup.
Metro.
full stop, the CGM Kamrup shall be at liberty to impose such other conditions as may be necessary to ensure that the petitioner continues to participate in the investigation process and cooperate with the same as and when called for, full stop. It is provided that the petitioner shall not leave the territorial jurisdiction of the investigating authority or the CGM Kamrup without prior written permission from the authorities concerned.
Medical treatment is going on.
You give an application, you tell
Yes.
them which hospital you are going to go and get yourself treated.
My lord, instead of 1 lakh, my lord, it will be 50,000, my lord.
You are not paying the money now.
My lord, I need.
Someone will stand to say, I will pay 1 lakh if you flee. Huh? You are not paying, and when it
If
is
I
in
do not
crores,
have,
you would
my
have
lord,
friends.
We give cash also.
When it is in crores, you would have friends. Is it not? This business requires friends in and around.
My lord, it is basically cases against.
All
your
right, 75,000.
Lordship, lordship at least.
75,000.
Obliged.
The Miss So-and-so appears for respondent number 1. Who is respondent number 1? Union of India.
Union of India.
Just formal party, my lord.
Huh?
Amended cost.
এতিয়া হিটু দিয়ক এইটো কিমান 66 তার নহয় 57 58 কি হয়
58, my lord, I am appearing. My lord,
This is 58
affidavit that is
এতিয়া মই হাতত লৈ your item is AB 1752
mine.
this should be 58
58.
okay
And
yes
learned friend has filed affidavit, my
That is still not, but Lordship, I have a copy that is still not tagged, Lordship can verify.
already this file is burdened with so many judgments.
I have placed, my lord, on the last occasion. Just now, my learned friend has raised the question whether anticipatory bail is maintainable or not. My lord, in Radhika Agrawal, Apex Court dealt with this, and the judgment which my learned friend is relying, that judgment is on different footing of Honorable Apex Court.
Okay.
Radhika Agrawal dealt with, my lord, custom, GST and all, your lordship, and came to the conclusion, your lordship, that whenever, my lord, bail application is filed with an apprehension that I may be arrested, that is required to be considered, and earlier, my lord, they are saying that anticipatory bail is not maintainable in GST case. So that was clarified by Honorable Apex Court. Here in this case, what has happened, my lord? My lord, according to me, complaint at page 18, as per their affidavit also, my lord, that I will show. Why apprehension, my lord? My lord, before coming to the issue, let me first clarify what is the given under the GST Act. In GST Act, my lord, if the allegation, my lord, is, my lord, less than 5 crore, then it is bailable and non-cognizable. If the allegation is above 5 crore, your lordship, then it is non-bailable and, my lord, cognizable, and maximum punishment under section 132, my lord, is 5 years, my lord. So on that context, my lord, a complaint was registered by GST authority saying that in a firm of so-and-so, there is a misappropriation of 12 crore, page 18, my lord. Because they are not filing, my lord, any formal FIR before the court. When they arrest the person, then they file a complaint. In that complaint, they are disclosing what is the offense. Page 18, my lord, kindly see. Para 2, my lord, page 19. That in a major detection involving fraudulent availment and passing of input tax credit, series so-and-so, having its principal place of business as so-and-so, has found to be involved in wrongful availment and utilization, passing of ITC on the strength of fabricated tax invoices without actual receipt or supply of goods and or services.
Hmm.
And the amount which they are saying, my lord, para 4. The preliminary
12
investigation.
crore, okay, then,
So this is the allegation. They are saying during the course of investigation,
Ah.
my name was also surfaced, your lord.
where?
And accordingly, my lord, they
Where
have
is your name?
my lord, my name is my lord Rishik, my name is Subrajit Bhattacharya, my lord.
Where is it?
My lord, in the complaint it is not there, but
Okay.
when I received notice, page 26, my lord,
Ah,
my name is there.
page
They-
40,
Page 26, your lordship.
26, yes.
Here, lordship will see to so and so,
You have received a notice under 35(3).
and
Very
case
well.
number is given, your lordship.
Hmm.
On the basis of this case number, my lord, right answer INS case number so and so, I applied for certified copy of the complaint. What is the complaint, your lordship? And the learned court, my lord, they have given this complaint. All right, they are saying another complaint, but the allegation is same. On the same complaint, my lord, interestingly, they have lodged an FIR with STF. Same issue. That matter is pending before this honorable court by way of quashing petition, my lord. Same allegation. Where in that case they are saying this is part of affidavit filed by my learned friend. Where they are saying, your lordship, same my lord allegation, and saying that I am also involved in the same allegation, page 80. And they are also saying, my lord, that since they are not well equipped, so they are unable to investigate the matter under the GST Act. So you also investigate, I also investigate, punish the person. Both are going parallelly, your lordship. So we approach this honorable court and matter is fixed tomorrow, my lord, for question. Now I am coming to, my lord, why apprehension is not there? Because, my lord, if your lordship will kindly see their affidavit, my lord. Copies there, my learned friend has given, and I am taking your lordship to page 48 of their affidavit. I have shown your lordship that Rishikesh Kalita and all, subject your lordship, it was given by state tax department to officer in charge special task force, Assam. There, here your FIR against so and so, the person, your lordship. There are the following person have been found to be involved in the said fraudulent activities. Here, serial number 2, my name is there, your lordship. And next page, you, my lord, 49. During the course of investigation conducted under Assam so and so, they are saying that it has been revealed that the above named taxpayer, in connivance with the other accused person, fraudulently availed. So I have shown, my lord, the complaint which I have annexed with my bill application, and STF complaint also, you also will see same FIR. And interestingly, my lord, at the bottom, bottom, my lord, page 49 bottom, what they are.
Show us why your custodial interrogation is not necessary, sir, so much. You are arguing the entire revision petition. We don't want that. Show us why you should not appear before them, why you should not be given, why they should not be allowed to have some custody of you.
My lord, so far as I am concerned, my
to
lord,
be,
everything, my lord, whatever the transaction, it is documented, number one, my lord. Everything is.
That means since every transaction in the GST Act would be would be documentary,
my lord,
there'd be nothing material to
I am
chase
coming to that,
around.
my lord. That's why, my
There
lord.
should be no arrest.
My lord.
No,
That's
don't
why
make it
Apex
non-valuable.
says
Make it
in the
non-valuable.
case of, my lord, in the case of GST, my lord, when the penal, in fact, Act has been enacted for, my lord, recovery of money, your lordship. The main object of the Act. But the penal provision was given. That's why in a Katina of decision, Apex Court says, unless and until the person is required because he is evading, he is not cooperating, in that case, arrest can be made. I will place, my lord.
You received this on 23rd of July. When did you receive it?
My lord, I have received, I approached this honorable court, and this
You were required to appear on 29th of July.
Thereafter, my lord, I have prayed for further, my lord, and accordingly, date was again fixed, my lord.
29th of July, and you filed this on 28th of July.
Thereafter, my lord, they have given another date, my lord. They have issued a press notice. Since, my lord, STF FIR is there, it was pointed out before this honorable court, and matter is fixed tomorrow, my lord. So far as STF FIR, if, my lord, I am ready, I will sit with the GST authority, because they also want, my lord, money has to be recovered. And one thing, my lord, I may submit your lordship, in GST, my lord, like for.
Since you were not supposed to be arrested, By the order dated 11/8.
My lord.
Why did you not go and
My-
appear and give them all the
I
documents?
was going, my lord, but STF, my lord. Same FIR has been registered in STF. It is not that I am page 40 that I have shown your lordship. Same FIR, my lord. And that matter is
He is on interim. We will fix it day after tomorrow. See what happens in that matter.
tomorrow, my lord, that question petition is.
Lordship, I am just pointing out one aspect. Lordship, page 26. Lordship has seen the case ID number. Case ID number, and Lordship now may kindly take up my affidavit. And here he has narrated the facts of Rishikesh Kolita is of same nature of transaction. And Lordship, his case ID is page 42 in my affidavit. Lordship, top hand after reference case ID is AD 1807260007045, and next page I have given the ID of Krishna Varman. He was required to appear in Krishna Varman case, and the facts he has narrated in the petition, that is of Rishikesh Kolita.
And this Krishna Burman
That
case,
was Lordship, if compare with
the Krishna Burman case does not contain Kalita's,
no
is unconnected with Kolita.
unconnected Kolita, though nature of transaction is similar. Both have defrauded
In
the state.
STF, my lord, they are saying so. It is connected. That's why I am saying. Rishikesh with Rishikesh Kalita. In STF case, your lordship can.
STF case Lordship completely different.
You are facing two cases.
My
And you are totally confusing us which case to
my lord,
pursue.
in STF case.
So we'll give you time till day after tomorrow.
My lord.
Either it is cost tomorrow or you appear as per our orders, future orders of day after tomorrow.
On Thursday, your lordship.
Huh?
On Wednesday.
Whenever you say Wednesday or Thursday. Huh?
Wednesday.
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 We'll require you to appear, is what we tentatively have in mind. And in case tomorrow the other case is cost, happy, not cost. Get a bail there so that you can go and appear. In the interim, no coercive action type something. At the request of the Learned Council for the parties, list the matter day after tomorrow, since another case involving the petitioner is stated to be listed tomorrow.
Fixed tomorrow.
Is fixed tomorrow. Is fixed tomorrow. Full stop. Day after tomorrow, go do.
Interim order may continue.
The interim order passed earlier shall continue.
Deeply obliged.
This 12 crores is with several people.
My lord. In fact, my lord.
He says, my lord, you
My
can
lord.
note that it is on.
My lord, in fact, before determination of amount, as per section 74, they can't say that this is the amount involved.
Cannot.
That I will place decision, my lord. They are saying 12 crore or 18 crore, whatever. That amount will come only after determination of by the assessing authority. As per section 74.
But that is somewhere in your computer. How will he reach it?
My lord.
How will he reach that computer that you are hiding with all the other
I am
things?
filing return, my lord. From there they can. I am regularly filing. It is not that we are not. This is on record, my lord.
It's a big record. Lots of persons are now being arrested. After filing of this AV, another 2 persons has been arrested from Siliguri. That's the hub of the.
Problem is, my lord, they are very interested in arrest, but conviction rate is very, very low, my lord.
What to do with conviction? See, we say fine of rupees 1,000 in default 6 months. Now your penalty of this 12 crores in default how many months? No, a total of 5 years. Yes.
Maximum 5.
1,000 rupees default 6 months. 12 crores full punishment is 12 years.
5 years.
5 years. So 1,000, if you keep on calculating 6 months for every 1,000, 12 crores would take you how many years actually?
So many years, my lord.
Restricted to 5 years.
My generation will go, my lord. Deeply.
Yes, 55.
Deeply.
May please, Lord.
Hey, my lord, FIR, your lordship will find at page 13, my lord. For elephant types of.
Those elephant things. Elephant tusks.
Recovered
Two
from-
elephant tusks recovered from him 3rd of July, he was arrested. Now, any report of any dead elephant anywhere near about
Well, that
from
elephant-
June to August?
So, well, whether
No, it
these-
has to be prior to 3rd of
but
July.
whether these are elephant tusks or not, for that, it has been sent to FSL. That report is pending.
He is required to be behind bars for that period till the report comes.
Yes, madam. Why?
He will change it in the forensic.
No. I'm not saying that. And that FSL report will say whether these are tusks or not.
Suppose FSL report says that they are not tasks. How do you give him back his time
Madam,
that he spends behind bar? And if there are elephant tusks, nothing more remains for him. He will surrender. He will cancel the bill.
Here, what has happened, my lord? 3 other persons were, because it is a chronological thing, my lord. One person, they saw one dead elephant, they took out the elephant tusk, my lord. They sold it, give to one person. Then it was given to this person.
So he is the receiver.
He's the receiver. my
Other
lord.
persons are not there.
Other persons.
One
are
of them is there,
arrested-
Ripon
uh,
Bosumotari.
Arrested.
One is arrested.
One is arrested.
The other one is not arrested.
Yes.
You will still have Ripon with you. Oh no, you will still have Satwan with you. You will still have Satwan with you. How many times have we called for the report?
First time.
Huh?
CD was called on last occasion.
It should have come with this CD. When was he arrested? July.
Right.
When did you send it
My lord,
for FSL? After 3rd of July.
my
When
lord,
did you send it
there
for
is-
FSL?
There is a. On 10/7, FSL received, my lord.
FSL received in the FSL laboratory, it was received at
It was
10/7.
received on the parcel received on 10/7.
From then on, nothing has come.
Nothing has come.
Do you actually need his custodial interrogation?
My lord, going by the police statement, my police report, my lord, there's nothing, my lord. They are suspecting the involvement of other person.
So other persons, whether suspect, death suspect, after nearly 2 months of his arrest, with the FSL report waiting, he will participate. Or if you want, we can give him an interim today. And on your FSL report being received, we will reconsider it. That is one thing.
That can be done.
Huh?
That can be done.
Yes.
There was already 53 days, man.
Huh?
There was already 53 days.
7 days more to go. How many days?
60 days of offense.
60 days. 7 days more to go.
Right.
Is it not? Heard, Mr.
Yeah, bro, man.
Learned counsel paying for the petitioner. Also heard Mr. R. Kaushik, learned APP representing the learned APP, full stop. The present petition is filed under section 483 BNSS, praying for bail to the petitioner, namely Rapan Bosumotari alias Ripan Bosumotari, arrested on 3rd of July 2026 in connection with Kochurgaon PS case numbers so and so, full stop. The learned counsel for the petitioner has submitted that the petitioner, having been arrested on 372026, is ready to participate in any further investigation that may be required and to cooperate in the same, full stop. He has submitted that. No, full stop. The learned APP has submitted that the forensic laboratory report is awaited to verify as to whether the recovered articles are elephant tusks, and further investigation is on to find out more suspected persons to be involved in the in animal and animal product trade. Full stop. In the circumstances of the case, I am of the considered opinion that the immediate further continued custodial interrogation of the petitioner at this stage may not be called for. Full stop. Accordingly, the petitioner shall be released on bail on furnishing a bond of rupees 20,000 with two sureties of the like amount to the satisfaction of
SGM M Gusaigaon.
SGN M Gusaigaon. Full stop. You say local sureties, huh? Local sureties. The petitioner shall not leave the jurisdiction of the investigating authority or the jurisdictional court during the time of this bail petition without written permission. Full stop. The learned SDGM shall be at liberty to impose such other conditions as may be required to ensure the participation of the petitioner in the investigation process during the period of this bail. Full stop. List the matter again on we'll have it on 2nd of September. On the 2nd of September, allowing the APP to procure the FSL report and have an updated CD, if so required. Huh? Mr. Kaushik, find out how many letters they've written or how many communications they've sent for the FSL report. They must have forgotten about it somewhere down the line.
Lordship may kindly peruse the last order, Lordship.
Okay.
First.
Yes. Mother making an allegation against the stepfather.
Lordship.
And you are giving only notices to the mother.
My lord.
Why do you imagine she will make any attempt to protect him or defend him in the rebut?
My lord. That is clear, my lord, but here in the, as per my lord, POCSO is involved, my lord. In the last time, the lordship was pleased to call for a report, my lord, service report, my lord. But in the, my lord, you have verified in your office also, my lord, in the record also, they have taken steps to speed post, my lord. That's why it is not received from our office also.
A speed post tracking report.
No.
412 days behind the bar, Lordship.
400?
12 days.
Like
The earlier order was for steps with AD. It was not pointed out to us. I would have given that order. Huh?
why, my lord, in the last?
No, earlier order is a speed post with AD. As well as through usual process, not through prevalent process. In the meantime, we'll also appoint an amicus. Take your steps. We'll take it up on 3rd.
Lordship, only short date, Lordship, in this week, Lordship.
Shorter than that. Will they be able to serve it?
My lord, that is.
Where is it? Gorchuk?
My lord, that is Gorsuk, but her residence is lordship phase 2, my lord.
Lordship, under the grounds.
Fakirganj, Dhubri.
Not Dhubri, Lordship, here in Gauhati, Lordship. Her mother stays in Gauhati.
You have given the address. Can we help? Please see your address.
Lordship. Lordship, on which grounds I am seeking bail, Lordship? In those grounds, Lordship, no objection can be given by respondent number 2, Lordship. That is my case, Lordship. After 412 days on any condition.
You take your step. We'll take it up on 31st. Make an attempt. We'll also have an amicus to address us on this issue.
Lordship, today, Lordship may appoint an amicus curiae.
No, my lord. First they will have to take steps. First they will have to take steps.
It will delay
We'll
the
appoint
proceeding
the
again,
amicus curiae on the particular question of law. To defend the interest, we'll give them the chance to come back on 31st. Heard Mr. J.S. Ahmed, counsel appearing for the petitioner, also heard Mr. Sharma, learned APP. The earlier order of this court records that the notices under section 47 of the BNSS served upon the petitioner was not in a language that he understood, and further, that the notice under section 48 of the BNS had been served upon the informant, who is the mother of the minor accused. Full stop. The learned APP has submitted that the service report on the respondent number 2 could not be obtained as the steps were taken to registered AD. Registered post with AD, full stop. The TCR has been received. Stop. In view of the circumstances where this court is of a prima facie view that service of notice upon the informant regarding the arrest of the accused may not suffice the requirements of law, comma, this court deems it fit to appoint.
Surface no other.
Huh?
Surface no other.
Sarfaraz? Mr. So-and-so. He writes Sarfaraz Nawaz. Or what? Sarfaraz?
Surface.
Nawaz. Mr. Sarfaraz Nawaz is the amicus to assist this court. Full stop. The respondent number 2 on receipt of notice would be at liberty to appear before this court. Full stop. List again on 31st of August. Counsel for the petitioner shall serve an extra copy upon Mr. S. Nawaz, learned amicus appointed today, and shall also take steps through in accordance with the prevalent notification for service of notice upon the respondent number 2 through the registry to be routed through the office of the learned PP Assam during the course of the day. Yes.
May I please allow? So this is 483 application, my lord, and the recovered substance is 0.6 gram. CD was called for on earlier occasion, my lord. And the difficulty is the 27A was inserted.
Yes.
The recovered substance is 0.6 gram, my lord.
0.6 gram, 100 gram more than.
It is from inventory, my lord.
Where is the inventory?
Page 15.
Yes, sir.
Well, today's CD notice.
What a small quantity, my lord, considering
No,
that, my lord,
27
already
days.
39 days.
6 gram without vials, huh?
27 is there.
They made a mistake in measuring and giving it to him.
My lord.
0.1 gram more went.
My lord.
Huh?
Give us
When were you arrested, sir?
for that, my
My lord, arrested on 16/7 and forwarded on 17/7/26. And as on today,
7,
39 days.
1.5 months. Huh?
My lord, for that may be given, my lord. We'll put it
Considering the
again.
length of detention, my lord.
We'll have it on the 27th or 28th. Short is
28.
that short.
28.
28.
Okay.
See, on the first opportunity when it
Yes.
is for his betterment. If he's a consumer,
My lord.
he will forget to consume, hopefully. And if he's a supplier, he will lose the chain.
Financing, my lord, 27.
Huh?
27.
With 0.6 grams. What kind of financing?
From the city, if not revealed, but from the city, maybe it reveals, my lord. We may involve in other testing also,
28.
my lord.
That is why 28.
My lord.
Otherwise, my lord, may release on interim bail, my lord.
No, my lord. 28.
From where?
Goroi Mari.
Down. And then why so many plastic vials you carry if you are only a consumer?
To consume, my lord.
We have our own doubts.
Consume for consume.
List again on 28th of August, allowing learned APP to call for the CD.
Obliged.
Yes, on interim.
May I please, your lordship? Lordship, I am an interim fight order dated 9/1/2026.
My lord, search it, submit.
17 years outside her school. I think recently also Supreme Court has granted bail to the mother and father of the IT engineer committed suicide. Abatement of suicide may not be made out. He's on interim. Lord, APP has submitted that the investigation has culminated in charge sheet being CS number.
Well, CS number 17/2/26. Oh, sorry, madam, dated 17/2/26, charge sheet number 38 of 20.
The petitioner having been granted an interim bail during the investigation process hearing, comma. This court finds that on the submission of the charge sheet, comma, further apprehension of arrest by the investigating authority does not arise in the present case. Accordingly, this anticipated bail petition is closed, leaving the petitioners to avail appropriate remedy if,
Lord-
as and when
Lordship, kindly
the
may be protected.
if, as and when summons are received for participation in the trial. Full stop. AB accordingly closed. Huh?
Lordship, we may be protected till appearance before the trial court, Lordship. Interim may be extended till.
Arrange for a where we can advise everybody that once the charge sheet is submitted, you had an interim protection.
Yes.
You appeared before the investigating authority.
Yes, yes.
What
Yes,
business would the investigating authority have arresting you now?
Yes, yes. Yes, yes.
I have allowed you to appear as and when you receive summons. Listen to the whole order.
Sorry, Lordship.
Takes too much time of the court. Yes.
Lordship.
36 CD not received.
Hmm?
CD not received.
Interim is there, Lordship.
23rd of March.
My lord,
Have they appeared?
that information I don't have.
Did you appear?
Lordship.
Have you appeared? Day after tomorrow.
My lord, Pilasi Para. Pilasi Para.
Just find out whether they have appeared.
Or can it be on Monday?
Monday. List again on 31st of August 2026, allowing the learned APP to have the updated CD in time of the past earlier content. It is noted that the CD had been called for on 20th in March 2026, and the petitioners had, according to the learned counsel for the petitioner, appeared before the investigating authority within the month of April itself. Yes.
My lord, item number 39, can it be taken day after tomorrow, my lord?
Why?
My lord, the counsel for the petitioner for medical urgency, he went to the medical. He requested me to apprise this honorable court. CD is here.
See, so day after tomorrow.
After tomorrow, my lord.
At the request of the learned counsel for the petitioner, comma, list the matter day after tomorrow, since he is not in a position to appear in the matter today. The CD has been received by the learned APP, which shall be retained. Yes. Next.
Oblige, lordship.
May it please your lordship. My lord, here the petitioner was granted interim protection, my lord. He appeared, and before also he appeared, my lord. Around 7 days to till he has appeared before the IO.
My lord,
And my lord, I pray, my lord. Along with my bail application, my lord, I have annexed 2 of the orders, my lord, by this honorable court at annexer 5 and 6, 79 and 81, respectively, my lord. These are, my lord, bail orders of the co-accused, my lord. On the same footing, my lord, my lord, and presently, my lord, on last occasion at around 12/8, on that ground of, my lord, that it appears that the prisoner have probably been interrogated, my lord. On that ground also, another co-accused was granted bail.
Probably here we have received the CD. If it don't go through the very voluminous, it needs some time.
Are you here tomorrow, sir?
I will be there, my lord.
Can it be tomorrow?
Yes, my lord.
If we
Yes,
don't
we
give
are-
an option, then it doesn't look
Yes.
good. Tomorrow?
Tomorrow.
26, 26 or 28.
26th?
Yes, 26th.
or 28.
We can give you the privilege of appearing through VC. We are trying to
Not
encourage.
at all, my lord. I am always available. I am
28th.
always available.
26th,
26.
28th.
My
Oh,
lord,
you are
23,
going like
26,
you
my
are
lord.
going like squeezing the toothpaste. I said
Yeah.
tomorrow, you said
No, no, no.
26, now you're 28.
My lord, otherwise, my lord,
He's on
He's on, you are on interim.
Yes.
28.
28.
28.
I think 24, no?
28.
My lord.
At the request of the learned APP who has submitted that he would require some time to go through the voluminous CD. List again on 28, interim order passed earlier continues. Upor likhibe heard Mr. T.H. Hazarika, learned counsel appearing for the petitioner, and Mr. Kosik, learned APP.
My lord. Deeply obliged. My lord,
Is CD received, sir?
Did he not receive?
My lord, what happened, my lord? I am victim of the CD, my lord. What happened, my lord? Case was listed on
Yeah.
earlier occasion.
Ah,
At that time, CD was in PP's office. Accordingly, my lord, CD was not produced. And
accordingly,
it was fixed. It was fixed on 27. Thereafter, my lord, from my client, I get information that CD has been sent by the OC.
Client, how can
Now,
client
thereafter,
I am not
thereafter
on
what
that.
happened?
It is for you to take your whatever actions.
My lord,
Yes.
my lord, thereafter what happened, my lord? Today, when I communicate with the PP that CD is available here, then it
Communicate
is
with
informed.
PP.
My lord,
Which PP?
PP office, my lord. That
Ah.
office of the PP.
Ah,
Then it is said that it is sent back on 21. 21 it is sent back. So I mentioned the case that CD is available, so case was listed instead of 27 today. So my lord, my humble submission before your lordship, in item number 9, similar case, my lord. Case number
Same
is case number is separate.
ah.
One is 70 like this, my lord. Now your lordship granted interim bail because I am the owner of the vehicle.
Here also you are owner of the vehicle.
I am owner of the vehicle. And another thing is this, my lord. On last occasion, your lordship, I produced before your lordship the receipt of the
We require you to file an affidavit.
Then I said that, my lord, I will file additional affidavit. So additional affidavit I have filed.
Yes, we
The
see.
money receipt is here.
Yes, yes. We see.
Now, my lord, my humble submission before your lordship, CD coming and CD going, my lord, in this way, I am tacked, my lord. I am in problem. So, my lord, I may be granted interim bail, my lord. And let the CD come.
Owner of the vehicle.
Owner of the vehicle.
88, as per
And,
my note, my lord,
Guru
the
Peta,
date was
Guru
fixed on
Peta.
27.
They made a mention.
And Kawas
must have
also.
heard the
My lord,
you must have heard the arguments made, not the arguments, submissions.
my lord,
This CD was available according to him.
my lord,
It was available to him in your office on 18/8/2026, but it was not produced before the court. It was sent back on 21st because the matter was next listed on 27th. Therefore, he had made a mention that if the CD keeps going back and not produced when it was here in the office of the PP, the man is running for his life for nothing. And that will be a fraud on the court because we had said that you are awaiting the CD.
my lord, whatever, because if CD is available in our office, my lord, that is obviously produced here. My lord.
I
It
know.
might have happened, my lord, because when the morning time, when the matter was listed or that time or second half or later time, my lord, that might have reached. My lord. That sometimes happens, my lord. It's not that if it is available on time, it is always produced.
Yes, yes.
Then, my lord, and that's why on 27/8 it was fixed, my lord. Then perhaps if CD was received on 18/8 as my lord stated, my lord, then it has been returned back, my lord. Then again requisition has been sent for.
This was also earlier brought to notice of the learned PP.
My lord.
This information through the particular channels percolating to different people. Should we bring it to his notice again? These are statements which will be available here.
My lord, may I submit one thing, my lord? But at least one thing is clear. That
You are praying for anticipatory bail.
Yes, my lord.
Investigating officer is telling your client, I have sent the CD, I have not sent the CD. What kind of a duty is he doing?
My lord, my humble
He
submission.
either arrests or he
My
says,
lord,
I don't need to arrest.
My lord, my humble submission before your lordship. When I am suffering from something, my lord, that is my pain. Either or way, my lord, my client get that information, the CD has been sent. And it is on 27, it is 50. Now your lordship, in the latest position, my learned friend will agree with me that CD is sent back on 21.
You do not know what he says.
That is on
Does your
record.
notes show, does your record show that it was received prior to 18/8/2026?
Yes.
No, my,
Can you have it found out from your registers there?
we have a diary in our.
Whenever it comes to your office, please find out. We'll take this up after 5 minutes.
My lord.
We are granting the bail otherwise for allowing him to appear and
My lord.
have his statements recorded. For this property kind of a thing, they are only the owners of the vehicle.
My lord.
It all a piece of piece of
Obligation.
3:30.
42. 42.
May I please, Lordship? Lordship, in this case, you have taken the steps, but service is not completed. So a case may be appointed, Lordship. Possible.
What has happened? Unable to understand.
It's a POCSO matter, Lordship.
Why do you want an anticipatory bail, sir?
Lordship, actually, the guy that,
The moment they appear, you will be in bigger trouble. So
Yes,
tell us why you want it now. 2007, 2027, 19 years, yes. He's 18. 19.
19.
Wait, case diary.
Is there may be written?
Case diary CD available. What
Case there may be written.
CD has been received. Service report on the respondent number 2 is awaited. List again on
Lordship, maybe 28.
2nd of September 2026.
Obligation, Lordship.
43.
May I please, Lordship? Lordship, I have filed the additional affidavit, Lordship, annexing all the orders, Lordship.
Yes.
Lordship has asked me to file the
Ah.
requisitions. All the orders, Lordship, I have from page 43, Lordship, it starts.
What is your name? Yes, why do you want to appear now? After all these years,
All these years means Lordship,
all these months?
I have been shown as a absconder in the charge sheet, Lordship. And if Lordship comes to page 25,
It is already split up. The case is split up, huh? Mr. Goswami, 262025, the case was split up.
It up. Now, I will not talk for him, my lord.
Huh?
Now he can, my lord, either appear, my lord, because he is not appearing, that is why, my lord, split up. My lord.
So what to do? We'll allow him to appear. On appearance, the
Trial court may,
MDW will be reconsidered.
trial court may decide as per law, my lord. And because kept in abeyance regard. till
We'll
date,
keep it in abeyance,
till date, till
allowing him to appear within the next 10 days.
10 days within.
Go and appear. Let trial court decide.
after all, Lordship, in the charge sheet also,
Huh.
nothing
What?
recovered from me, Lordship.
Oh, that doesn't mean you'll avoid trial and
No, I am ready to appear, Lordship. That is why I have come.
you
before
should have
this
been
court.
ready to appear sometime in 2025. Which is the order you are challenging?
It's from the beginning.
You are praying for bail. What is the last order you had given here?
Lordship, now I have annexed all the orders, Lordship. So NBW was issued, Lordship, on 22/4/25 on the second.
Huh.
From there, Lordship, it continues NBWA. And I have been shown as a absconder in the charge sheet, Lordship.
Why are these two orders different? At page 69, it is the order of 23/6/2026. And page 28 is again 2026, same order, a same date. We'll keep the NBW in abeyance till 14/9. Go and appear there.
Give 15 days, Lordship.
14/9, you appear.
15 days.
You want 15 days time?
No, Lordship, up to
Giving more,
14.
my lord.
1, 2, huh?
14. Prior to 14, I will. On or before 14.
Huh?
On or before 14.
Why before? You
Not-
appear on 14/9, will protect you till 14/9.
Or 14 is the date fixed. Lordship.
If you appear before 14/9, this bail will be in operation. So again, 14/9, you don't have to pay for bail again. We don't want that to happen. We want you to appear till 14/9. Till that date, you will not be arrested. On 14/9, trial court will decide whether you can be allowed to remain on bail in view of the past conduct. We will not say the past conduct. We'll just to consider your case. Yes, heard, Mr.
M. Ahmed.
M. Ahmed, Learned Counsel, appearing for the petitioner. Full stop. The order dated 18/8/2026 required the petitioner to file, to bring on record all the past orders, it was PAST past orders, PASSED past in the trial proceedings against the petitioner. Full stop. The said orders have been brought on record by filing an additional affidavit. Full stop. Mr. M. Ahmed has submitted that the next date fixed for the trial is on 14/9/2026, on which date the petitioner shall appear before the learned trial court. Full stop. In view of the submissions made, the non-bailable warrants of arrest issued against the petitioner by the learned trial court shall remain in abeyance till 14/9/2026, on which date, on the appearance of the petitioner before the learned trial court, and on the petitioner moving an appropriate application, appropriate application for being allowed to remain on bail, the learned trial court shall take into account the attending facts and circumstances and consider the petition prayer made by the petitioner to be allowed to remain on bail. Full stop. It is made clear that this court has not made any observation regarding the merit or demerit of allowing the petitioner to remain on bail at full stop. The same shall be decided by the learned trial court on the appearance of the petitioner. Anticipated bail petition accordingly closed.
Till that, my lord, it will remain in abeyance. And will.
Go outside YouTube and you find out what we have said.
Publisher.
Hmm.
No, this anticipatory bail was filed, before the filing of charge sheet, in the meantime, charge sheet was filed,
Charge sheet has been filed.
Yes, and 3 times this court has been called for TCR, but TCR has not come,
No, if the charge sheet has been filed, then do we require to keep this pending?
We may be directed.
What did you do?
Let him appear before the trial court once.
As and when he receives summons, is it not?
On such appearance, we may not be arrested,
Why? To face trial and during
To-
investigation
to
are two
face
separate
trial.
incidents. He has heard Mr. So-and-so learned counsel appearing for the petitioner, also heard learned APP. The learned APP submits that the investigation has culminated in
Charge sheet number 60/26 dated 30/5/26.
full stop. Since the charge sheet has been submitted, comma, there appears to be no apprehension of the arrest of the petitioner by the investigating authority. Full stop. Accordingly, this anticipatory bail petition is closed, allowing the petitioner to appear and pray for appropriate relief if, as and when summons are received by the petitioners in the event they are sent up for trial. Disposed of.
What do you want?
Closely. Closely.
On 18, TD was received lately, my lord.
Huh?
Lately, my lord.
Late.
in our office. So
Heard
then
Mr. M.S. learned counsel appearing for the petitioner, also heard Mr. R. Kaushik, learned additional public prosecutor for the state. Kindly tell Mr. Sheikh
Yes, Your Honor.
that the CD was received belatedly after the matter was there, and therefore there is nothing wrong in the office of the PP. Allegations need not be made only because petitioners are giving information. Kindly have your information as to how these things are.
Yes.
Also heard Mr. R. Kaushik, learned APP, full stop. The learned counsel, Mr. M. Sheikh has submitted that the affidavit bringing on record the receipts of the trade of the cattle has been brought on record. Full stop. In the facts and circumstances of the case, the petitioners, who claim to be owners of the vehicles involved in the seizure of the cattle, are directed to appear before the investigating authority on or before the 3rd of September 2026 to participate and cooperate in the investigation. Full stop. The learned in the event of their arrest, they shall be released on bail on furnishing a bond of ₹10,000 each, with 2 sureties each of the like amount to this. To the satisfaction of the investigating authority. Full stop. Call for the updated CD on
my lord, 7th of September.
7th of September 2026.
Orders, item 44.
Objection. May I please, Your Lordship? In this case, the Honorable Court is directed to take justice service upon the respondent number 2.
Have you done it?
Taken if the petitioner went to his house, respondent number 2's house, but he not found him. So kindly allow another 1 week's time to.
At the request of the learned counsel for the petitioner, list the matter after 1 week to effectuate justice service on the respondent number 2.
Objection.
My lord, here service report awaited, my lord, as per office note, my lord. Here is the appeal, my lord.
He is undergoing
No, Lordship.
imprisonment.
No, Lordship. Sahi is under
Huh?
Is on bail, Lordship.
He's on bail. Await service report on the respondent number
There
two.
is an
list-
interim order also, Lordship. It may be continued.
Await service report on the respondent number two. List again on. When can you have it?
My lord,
15th of September
My lord.
2026.
My lord.
Interim order passed. Interim order.
3 years
Must.
conviction, my lord. POCSO Act, under conviction 3 years, my lord. That's why.
The allegation is enough, sir. It should be removed where possible. The conviction should go according to him.
Section 8 POCSO, RI for 3 years.
Interim order passed earlier. Interim bail granted earlier continues. 15-9. Below the same.
56.
I am pleased, your lordship. Lordship, here we have been served our dusty service, lord.
You served through Dusty.
Yes, sir.
The learned counsel for the petitioner draws attention of this court to the affidavit showing service of notice by way by Dusty on the respondent number 2. Stop. Notice on respondent number 2 is deemed to be complete. Stop. List again on 14th of September for admission.
57.
May it please your lordship. Lordship, as per the office note, service of notice upon respondent number 2 was served on 4/8/2026, lordship. Press service of notice.
Do you know the difference between service of notice and steps taken?
Sorry, your lordship.
Huh? What are the allegations?
Lordship, false marriage promise, lordship.
List again on 17th of September, awaiting service report on the respondent number 2.
48.
May it please, your lordship. Lordship, in this case, service not yet complete, lordship. And-
Additional PP to take. Additional PP, you are required to take instruction.
My.
You got it on 22/7, sir. More than a month gone. List again on.
Your-
Oh, this is criminal appeal for what?
and-
Condonation of delay.
Yep, lordship.
Condonation of delay.
Yes, lordship. Here 17 days,
How many days?
317 days,
300.
How many days?
317 days. Kindly, lordship, grant from them to take steps through justice service laws.
We'll have it on 10th of September. Have your
Well.
list again on 10th of September, allowing learned APP to have instructions on the
Service.
service of notice on the respondent number 2.
59.
More than a month, Mr. Sharma, have your instructions?
May it please, your
Yes,
lordship.
madam.
My lord, in this case, my lord, although the AD cards are not received,
Hmm.
we got to know that the services were complete because the track report says, well, it was delivered. Therefore, my lord, it has been listed today on my instance, my lord. We are.
But the
against-
track report has to be on record before we
My
can,
lord,
presume that.
my
fact.
lord.
Heard Ms. Chakraborty, learned counsel for the petitioner, also heard Mr. Sharma, learned APP, full stop. The petitioner has submitted that as per the postal track records, the notice has been received by the respondent number 2. However, the said postal track records are not before this court. Stop allowing Ms. Chakraborty, learned counsel, to place on record the postal track receipt list again on 11th of September 2026,
My lord, can it be after 12th, my lord?
14th of September 2026, registry would also have a updated status on the service of report if returned.
For hearing, item 20.
This is criminal appeal.
Lordship, kindly take the IA number 936.
No.
Where I have annexed the Zahar Lordship.
It's okay, but you are available. Okay.
Transcript for final hearing.
Why is it come upon orders then?
It is
Oh, it's
hearing.
for hearing, okay.
For hearing.
What is your ground basically?
Lordship, there is no specific allegation against the appellant number 1.
Okay.
Lordship, kindly have a look at the Azahar and more than 1 year already in custody.
Are you on bail?
No, Lordship. That's why I'm.
You are behind bars.
Lordship, more than 1 year.
Punishment.
Section 8, Lordship.
And what was the this thing?
5 year, Lordship.
Punishment is 5 years.
5 year.
Today is Monday, no Tuesday. Monday. We'll have it on Tuesday.
Lordship.
Tomorrow, not tomorrow, Thursday. Thursday.
Lordship may consider bail, Lordship.
A little,
more than 1 year.
we are a little hard pressed today for personal inconvenience. So we would like to take it up on Thursday for disposal. Since you all have the documents, TCR is here, he'll go through the TCR in the meantime. We will not go for construction of paper books on 5 years.
Lordship.
5 year sentence, 1 year undergone.
Lordship.
Show us the correct position. Let you go.
And the Lordship, against the appellant number 1, there is no specific allegation either in the Azahar or in the 161 or in the 160.
How many appellants?
2, Lordship. Against 2, appellant number 2, there is allegation that he tried to outrage her modesty. Initially, case was registered under section 354 and 506. At the conclusion of the trial, Lordship, again case was remanded to the learned POCSO court and fresh charge was taken. And then proceeded afresh, annexing section, incorporating section 8 of POCSO, Lordship. There is no specific allegation against accused number 2. Whatever it is, appellant number 2. Lordship, kindly look at the page 10 of my interlocutory application and page 13 of our statement of the alleged victim recorded under section 161.
No, we are not listening today. We are just trying to find out. কি মাহ চলি আছে অগষ্ট দেৱালী নহয় Thursday have a look something in an auto. Huh? 1 year undergone. Is there a minimum punishment for it?
It is maximum.
Minimum is 3 years.
3 years.
Minimum is 3 years.
Bail part may be, Lordship.
Thursday, either of the two.
Lordship, it may be listed in the order column, otherwise it will.
Remind us in the morning. Remind us in the morning.
Lordship. Or otherwise, Lordship may.
Want us
For order column, Lordship, the IA may be considered.
There's already an order for final hearing.
There is an order for final hearing. Why should we bring it back to the orders? It will list again on Thursday.